Before we start, I'd just like to remind colleagues about the use of the second person, i.e. you. Can you please refrain from using you unless you're actually directly addressing me? So I just remind people of that, if you would. And as for interventions, interventions should be sort of a vignette, not a disquisition. In other words, a sketch, not an oil painting. So I'll remind people if their sketch becomes an oil painting. Nice shot.
Thank you, Chair. We're talking about, I was speaking to Amendment 181, Chair, before the adjournment, and I was talking about the two obvious problems with that amendment. The first problem is that the amendment removes references to the Equalities Act and the Mental Health Act, which previously defined who did not have a disability or mental disorder. But having removed those definitions, it does not define disability or mental disorder within the bill. So I'd like to understand what definition will medical practitioners and indeed applicants use to determine who does and does not have a disability or a mental health disorder. And I appreciate the member from Spen Valley explaining that actually it was on the advice of what the advice that she took in relation to the Equalities Act and the removal of the Equality Act, because it takes out, because people who have cancer also can be declare themselves as disabled people. However, that leaves a real opening which weakens this amendment even further. And I can't understand why we would remove one clear of source of definition but not provide a replacement. That, for me, Chair, raises serious concern. But there is an actual bigger problem with this clause, as it would be changed by the Honourable Member's amendment. The amended clause would still say that someone could not be disqualified from assisted dying only, and again I emphasise the word only. It leaves the door open for individuals with mental health issues, disorders or disabled people to qualify for assisted death based on the physical consequences of their condition. If the goal is to prevent people with mental illness or disabled people from qualifying, then this amendment fails to do that. This amendment weakens rather than strengthens the bill's safeguards. By retaining the word only, it leaves the door open for individuals with disabled people or with mental health conditions to qualify for assisted death based on the physical consequences of that condition. As we heard in oral evidence, there are now 60 documented cases of individuals with eating disorder who have died by assisted death internationally. In these cases, physicians justified... Happy to give way.
Will she accept that nearly all of those cases are in jurisdictions whose schemes bear no resemblance to the one being proposed here?
Well, I accept that the majority of those 60 referred to are in jurisdictions, but to me it doesn't matter whether there's a majority or there's one death is too many, and I'm sure the member will agree with that. So whether it was two, as the evidence was from Oregon, but there is also, it's also important to reflect upon the fact that Oregon doesn't record. So the people who have anorexia, and by and large it's women who do have anorexia, who do feel that fit that criteria, or are on a trajectory to fit that criteria because they decide not to eat and meet that criteria for assisted death, they don't have a record. So we can't exactly rely upon the two that have been found, and those that have been found were only found because of the research that was carried out. So that doesn't quite satisfy that question. Thank you.
The Honourable Lady agree with me that it really doesn't matter what happens in other jurisdictions. The question is, does this legislation prevent people who are currently suffering from anorexia from seeking an assisted death or not?
I thank the Honourable Member for her intervention, and I completely agree with what she has just said. Coming back to the physicians that justified eligibility by citing that physical complications of anorexia, not just the mental disorder itself, that was in those cases used. We do know that all of them that have been cited, the 60 that have been cited, did not have a terminal illness other than the one that was caused by anorexia, because that then fit that definition. Under this bill, the same could happen here. In response to the member opposite, eating disorders or substance use disorders could still qualify if a doctor determines that the resulting physical deterioration meets the criteria for terminal illness. This amendment, and I will be talking to anorexia per se much more in detail in a further amendment that I've tabled, Chair. This amendment also removes references to the Equalities Act and the Mental Health Act. It does not define disability or mental disorder within the bill. That raises serious concerns. And so to that end, I will not be supporting this amendment, because I really, really would encourage members of this bill committee to strengthen and not weaken that particular amendment, this bill in its entire in regards to these amendments. The Act does define mental illness and disability as taking a clear medical model, and again, it's not clear if she's further suggesting that a new definition should be used. But again, I'm going over ground that I've already gone over. I'll move on, Chair, if I may, to speak to Amendment 10. Just bear with me. Amendment 11, I think. No, actually, I've covered some of that. Thank you, Chair.
Daniel Francis, sir.
Thank you, Chair. The amendments before us have left me in a significant quandary, really, as some members are aware. I'm concerned that while the proposers are genuinely seeking to improve the bill, I believe that potential legal loopholes do remain as a result. Prior to second reading, the Equality and Human Rights Commission produced a briefing note on the Terminally Ill Adults in Life Bill. And in that briefing, they included a specific section relating to discrimination and equality considerations relating to the bill, which stated it may also particularly impact disabled people. We recognise that this bill is focused on assisted dying for adults who are terminally ill and does not propose access to assisted dying on the basis of disability or chronic conditions. However, there is not always a clear line between terminal illness and disability. Disabled people can also suffer from terminal illness, and illness may itself amount to a disability. Parliament should note that the exclusion of disability as a standalone criterion for accessing assisted dying does not mean that the rights of and protections for disabled people do not need to be considered in relation to this bill. And I note that my honourable friend for Spen Valley's amendment seeks to clarify these matters, but I remain concerned that Amendment 181, with its reference to only because they are a person with disability, still therefore includes the ambiguity that she is seeking to remove, and I understand the legal advice that she's received on this matter. Because my view is that despite removing the reference to the Equality Act 2010, the Equality Act still sets out that disability is one of those specified protected characteristics. And Section A9 of the government's guidance on the Equality Act sets out that the Act states that a person who has cancer, HIV infection, or multiple sclerosis is a disabled person. This means that the person is protected by the Act effectively from the point of diagnosis. And I remain concerned about this point because I've previously raised my concerns about the language that was used at second reading. You know, if I had spoken at second reading, I would specifically, this is one of the points I would specifically have spoken on, because the language we heard at that point and through the passage was that this assisted dying is not eligible for disabled people, but you know, clearly within the Equality Act they've just diagnosed 3 disabilities which clearly may or may not be eligible under this bill.
Will he give way?
Absolutely.
I'm very grateful. I think he's making a very important point, and it picks up on the Honourable Lady's observation earlier that indeed there is a link with, through the Equality Act with disability here, and I think it's absolutely right that we address that. Does the Honourable Gentleman agree that the way to address that is not to accept the amendment from the Honourable Lady, which retains these words, these dangerous words only, and for the avoidance of doubt, to accept Amendment 11, which excludes those words and ensures that you could not get an assisted death by reason of disability or mental illness? But what we need to do, because of this concern about the Equality Act, is perhaps table a further amendment, and I'm waiting for the Chair's ruling on whether it's possible to do that at this stage, that would exclude the Equality Act from the operation of this clause. And in fact, Amendment 181, I think, does exclude doesn't have this reference to the Equality Act in it. The bill itself does, So we should follow that point, not have the Equality Act, but not use the Honourable Lady's amendment, which doesn't move us forward, but use Amendment 11, which does. I hope that's clear, and I hope that might satisfy the Honourable Gentleman's concern.
Thank you, Chair. Well, I'll turn to that, and again, I understand what Amendment 11 seeks to do, but I think, as you've said, my personal view is most probably a hybrid somewhere, because I don't think either of them completely seek to achieve what we want, and as I will turn to in a moment, I will be seeking the Minister's advice on this in due course. I understand the lead member's legal advice on this matter, and I understand all the amendments have been tabled in very good faith, but I am concerned about the loopholes that could remain. Because the language, as I said, that we heard at second reading was assisted dying will not be available for disabled people. And what I would say is, imagine an individual who does not consider themselves to be disabled. If they were diagnosed with cancer tomorrow, our legislation states they would become a disabled person from the point of that diagnosis. And that person could live with that cancer and be receiving treatment for a considerable period. And they'd continue to have no other disability, but at the point where they receive that 6-month diagnosis, they'd be eligible for assisted dying due to the same disability they've had for a very considerable time. And that would remain the only disability they've had in their entire life. And I do still remain concerned that the wording in Member for Spring Valley's amendment does still talk about disability and still potentially has that loophole within it.
Would you wait on that point? Thank you, Chair. I mean, I think he's made an interesting point there, but actually that is the purpose of the bill. So if someone did have a terminal cancer diagnosis with 6 months left to live, the whole purpose of legislation is that they would have the choice of assisted death. If indeed, as some of the stories we've heard, Chair, they may have relatives who've had a similar cancer, they've seen them suffer, they've seen what their death has looked like. Surely that is the purpose of the bill, and I understand that maybe people who disagree with the purpose of the bill, but that is actually the purpose of the bill.
Thank you, Chair. And I hear that point, but again, my own post bag, those that berate me for not supporting the bill, of course, in many cases, talk about their loved ones who have MND or Parkinson's, but of course, that currently, from my understanding, would be exempt. And my concern is, in some cases, in the oral evidence, that was what we heard, my concern is that we need to be very clear on what disabilities, what conditions are eligible within the wording, and I'm still not clear that the amendments before us would nail that down, so to speak. And that remains my concern, that we, as I will speak to in a moment, that we will be open to legal loopholes or legal challenges as a result of this wording. So I think we should still be concerned about how there could be legal reviews of legislation based on indirect disability discriminations as set out in the Equality Act 2010. That legislation talks about indirect discrimination happens when there's a rule, a policy, or even a practice that applies to everyone, but which particularly disadvantages people with a particular disability compared with people who do not have that disability. And it cannot be shown to be justified as being intended to meet a legitimate objective in a fair, balanced and reasonable way. Because I believe that by moving this amendment to allow, rightly under the premise of the bill, to allow the inclusion of cancer and some other disabilities set out in the Equality Act, I believe that there'll be other disabilities not eligible for assisted dying that would then in due course be argued do not meet that criteria. And despite the appointments made in this committee and to the House in due course in good faith, there could be loopholes that allow the criteria to be made more widely available. Other amendments in this grouping retain the reference to the Equality Act 2010, and I think that equally causes potential legal challenges down the line for the reasons the member for Spin Valley outlined this morning. So I'm not attempting to be deliberately difficult, but I'm not actually sure that any of the amendments completely achieve what members seek to achieve in due course here. I'll wait to hear the view of the Minister on the matter, but I'm concerned that as things stand, we may take this clause back to the House and not completely have satisfied the aims of members by allowing those with cancer to seek assisted dying. There could be a tightening or a loosening around the rules for other disabilities. I fear there could be further manuscript amendments to come on the matter, but I'll await the Minister's comments on the Government's view on the robustness of these amendments if they were to be introduced. Thank you, Chair.
Thank you. Lewis Atkinson.
Thank you, Chair. I just want to come back to the bill as currently drafted. The key factor of Clause 2 for me is the focus on terminality. That is what determines eligibility. That death is reasonably expected within 6 months. The clauses that we're discussing subject to amendment are just merely clarifying, rightly, it's important to clarify, and again I also wait to hear the government's guidance on this, that solely having a disability, or indeed a mental disorder, it does not in itself provoke eligibility. I fear we are overcomplicating matters, and I want to just, the focus on terminality, it's in the name of the bill, the Terminally Ill Adults End of Life Act, is what we are focused on here today. And I would just urge members in considering amendments, including 181 from my honourable friend from Spen Valley, on that point. If I may just respond to a few points on other amendments in this grouping. The member for Bradford West referred to the evidence of Chelsea Roth, I think it was, who talked about potential deaths from anorexia worldwide. The language in the bill around inevitably progressive, I would draw members' attention to the language around inevitably progressive. So I've done a little bit of research over lunchtime. That language reflects the language, the progressive language in the Australian Act, on the Australian Acts. It does not, that language is not present elsewhere, certainly not in the Netherlands, which is clearly a totally different model that is not comparable at all. And I agree with the honourable lady that whether it's 1 death or 60 deaths or whatever, that is too many. But we shouldn't not be citing, I would suggest, large numbers where they're clearly from jurisdictions which have got a totally different model. The difference is around the progressive. And in defining in this way, by inevitably progressive, this is tighter than anywhere else. That's before we get on to the other levels of safeguards around a third tier, which, remember, is not in place elsewhere in the jurisdictions to which Chelsea Roth made reference. So I would just draw members' attention to that. In terms of the amendments from the member from East Wiltshire, 399, etc., I have sympathy with those. I think there is, on the understanding and await ministers' input, that a constellation of illnesses, diseases, etc., that can combined lead to an inevitable end of life. I think it might be a useful clarification on that. Certainly that is no one's intention, I think, to widen this to a much better way. And if that is an example of where, as a committee, we can work constructively together to make sure that the clarification and the will of the House as expressed in second reading and beyond is expressed, then I hope we could potentially do that. Thank you, Chair.
Thank you. Dr. Samanofa.
I'd like to make a very short comment. Thank you, Chair, for allowing me to speak. I think it's very important that this committee doesn't get too hung up on anorexia, because I think the bill actually is very, very clear about what this excludes. And deprivation of nutrition is always reversible. So what would happen in a case of someone who's anorexic, who is about to die, they would go into multi-organ failure and be unconscious and be unable to give any sort of consent. Before that, then nutritional deprivation is reversible, and this is not covered under this bill. So, I do... sorry.
I just wanted him to comment on the reality within our NHS at the moment that people are described as terminally ill with anorexia. They are given the label of terminal anorexia. They are put on palliative care pathways because it is assumed that their condition is not irreversible. So doctors today in this country are concluding that people with eating disorders are going to die, and they're treating them accordingly. Is he aware of that, and how does that affect his comment?
Yeah, no, I'm not aware of this, and I believe that it's always reversible until you go into the absolute terminal stage of multi-organ failure. Before that, you can reverse nutritional deprivation in that way. So I don't accept that. And I do think it's really important that we look at the bill in all its detail, and I think it has enough safeguards to exclude someone with anorexia in this bill. Thank you.
Right, thank you. I've received an amendment from the member for East Wiltshire who wishes to move a manuscript amendment, and a manuscript amendment, as the honourable gentleman knows, requires a very high bar to accept and one would require exceptional circumstances, and I don't believe those exceptional circumstances are present. And the Honourable Gentleman will also be aware that further amendments can be made to this clause that can be considered at report stage. So that's my decision on that matter. Minister.
Thank you very much, Mr. Chair. It's a pleasure to serve under your chairship. Whilst it's for Parliament to progress any bill, the Government has a responsibility to make sure that legislation that passes on to the statute book is effective and enforceable. For that reason, the Government has worked with the member for Spen Valley, and where changes have been mutually agreed upon between the member and the Government, I will offer a technical, factual explanation and rationale for these amendments. That applies to Amendment 181 in this group. This group of amendments is linked to how the definition of terminal illness in the bill applies to those with a mental disorder or disability. Amendments 399, 400 and 401 remove the term medical condition from the definition of terminal illness under the bill. So only those with an inevitably progressive illness or disease would be able to request to end their life under this Act, rather than those with a medical condition or disease as currently drafted. This amendment potentially narrows the scope of those who may access assisted dying services. However, clinical advice suggests that the use of these terms has changed over time, may not be used consistently, and remains debated in both medical and lay circumstances. Removing the term medical condition may lead to disputes or protracted debates about whether a particular condition is or is not a defined disease or illness, despite there being medical consensus around whether it will lead to death within 6 months. Turning to Amendment 11... I will give way.
I'm grateful for that clarification, but it does rather concern me. Is the Minister able to elucidate exactly what conditions might fall into this category of medical condition that would not be captured by illness or disease? And does he accept the point that I made in my speech, which is that the interpretation of the law by the court will be that this expands the existing law on terminal illness beyond illness or disease, which is in current law? So what is the new, what are the new conditions that will be captured by this term?
I thank him for that intervention. I mean, I think what he will have picked up throughout this debate on every day that we've met is that the Government is concerned about adding or taking away things that deliver clarity and stability and familiarity in terms of the terminology. I have to say his amendment is one where I'm quite torn, because I absolutely see where he's coming from, and it's one of those situations where my position as a government minister is made somewhat more complex by my personal view that I think the amendment that he's tabled is perfectly reasonable. And when I look at it, my instinct is that, speaking personally as a Member of Parliament rather than as a government minister, that the remaining terms in the bill, if you remove medical conditions, do continue to cover the waterfront, if you like, or the spectrum of conditions. So I think possibly this is a case where there's been an overabundance of caution on the part of the Government. So I am delivering the Government's position on this, but I want him to know that that won't necessarily determine how I vote if this does go to a vote.
I'm grateful. I'm grateful. I was going to remind the Minister that he's, in his strange Jekyll and Hyde personality, speaking as a Minister, voting as a Member of Parliament. So if he's given the Government's view that this amendment is not acceptable, but he himself thinks it is, I hope he will vote for it.
I thank the honourable member. It's absolutely a well-made case, and I'm still reflecting on it because of the, as you say, the somewhat complex nature of my role on this committee, but I am inclined to support his amendment. Amendment 11 also seeks to amend Clause 2, 3 in the bill. Our assessment of the effect of this amendment is that a person who has a mental disorder and or a disability may not qualify under this bill as terminally ill, even if they have an inevitably progressive illness and can be reasonably expected to die within 6 months. There may be concerns from a European Convention on Human Rights and Equality Act point of view if this amendment were passed as currently drafted by committee. This is because its effect would be to exclude people from the provisions of the bill if they have a disability or a mental disorder, which may not be the intention of members who have tabled this amendment. Turning now to 181, in executing our duties to ensure the legislation, if passed, is legally robust and workable, the Government has advised the member for Spen Valley in relation to 181. This clarifies that a person who seeks assistance to end their own life based only on a mental disorder, a disability or both, would not be considered terminally ill for the purposes of the bill. Therefore, such a person would not be eligible to be provided with assistance to end their own life under the bill. As drafted, someone who has a disability, a mental disorder or both, and who also already meets all the criteria for terminal illness set out in the bill is not excluded by this amendment. Therefore, this amendment brings important legal clarity to the bill. 283. This amendment would set out that a person who has one or more comorbidities alongside a mental disorder within the meaning of the Mental Health Act 1983 would not be considered terminally ill by virtue of those comorbidities alone. The reality of modern healthcare is that many patients, not least those towards the end of life, will be dealing with several conditions or comorbidities. The term comorbidity in a clinical context can sometimes be used to distinguish the main problem someone is experiencing from additional but less serious problems. But it can also be used by those specialising in one or more other aspects of a patient's care to distinguish their area of focus from other issues. In the context of the bill, the essential test is whether any morbidity, comorbidity or otherwise, meets the requirements of the bill. While it is unlikely that a terminal morbidity would be thought of as a comorbidity, it is not, for the reasons set out above, inconceivable that it might, and the particular phrasing of the amendment, notably the term alongside, potentially increases that possibility. The effect might be that a condition that would otherwise be considered terminal would instead be considered a comorbidity alongside a mental disorder. This amendment would prevent a person with a mental disorder who would have been considered terminally ill, but for this amendment, from accessing assisted dying services under the bill. As I said earlier, the Government has taken a neutral position on the substantive policy questions relevant to how the law in this area could be changed. However, to ensure the legislation works as intended, we have advised the sponsor in relation to Amendment 181 to further clarify the bill so that only having a disability and/or mental disorder does not make a person terminally ill and eligible for assistance in accordance with the bill. I hope that this...
I thank my honourable friend for giving way. I think that much of the discussion on this particular amendment 181 has been centred around the word only. And so just to kind of get a clear sense of clarification on this point, would someone with an eating disorder who later was diagnosed with a terminal illness still be able to access an assisted death if that was required under this amendment?
I thank my honourable friend for that amendment. My answer to that question is yes. My understanding is that as long as the terminally ill 6-month criteria are met, then that person would qualify for assistance under this bill.
Sorry, just to be absolutely clear, as if I wasn't specific enough as well, but just for clarity of everyone in the room, if that terminal illness is as a result of the eating disorder rather than, say, they also get diagnosed with a terminal illness due to cancer, would that person, i.e. if they're becoming terminally ill due to an eating disorder, fall under this, even with 181? Sorry if you've already made that point. It must be absolutely clear.
No, my understanding is that Amendment 181 is clear that the qualification for accessing assisted dying has to be based on the definitions that are put in place in the bill, in the main body of the bill, and the amendment, if passed by this committee, will make it clear that an eating disorder does not qualify for access to that service. There has to be another clear definition that does qualify under the terms set out in the main body of the bill.
I just wanted to illustrate to the committee that people with eating disorders are already subject, certainly as they come towards the end of their life, already subject to quite assertive action by the state. So, for example, over the last few years, the Court of Protection has generally, where a hospital has detected that an individual is effectively trying to starve themselves to death, the hospital has applied to the Court of Protection and got orders for forcible treatment. and in that application it is determined that that person does not have mental capacity to make decisions about their own medical care. So I don't want the committee to labour under the illusion that people with anorexia or other eating disorders are going to kind of wander up and suddenly ask for an assisted death. If there has been a detection of that they are trying to get themselves eligible by effectively causing organ failure by starvation, then the system would have intervened well before that, effectively, to force them to be treated.
My honourable friend, the honourable member, makes an excellent point. I think it sort of goes back to our basic view that there are some amazing health professionals in our healthcare system who do fantastic work. Eating disorders are a truly tragic condition, and of course there is all sorts of support in place. It's not always perfect, it's not all exactly how we want it to be, but I think it would be a false move by the committee to think that this is an either-or situation. This is a both-and situation, and of course it's not always perfect, but we should also, I think, pay tribute to the amazing health professionals we have who look after all sorts of people with all sorts of conditions, including eating disorders.
Will the Honourable Member give way? Does he agree with me that it is also reassuring if we look at clause 2 subsection 1a and the language of cannot be reversed by treatment? I believe in some of the evidence by Professor Emily Jackson that indeed someone with a condition that is not inevitably progressive or which could be reversed by treatment would be ineligible under the Act, which covers the case raised by my honourable friend for Ipswich.
My honourable friend makes an excellent point. She brings us back to the fundamental point made in the bill, which is that it has to be an inevitably progressive illness, and eating disorders do not fall under that definition. That's very clear. So I hope this explanation and the observations I've made on the other amendments are helpful to members of the committee in their consideration. Thank you, Chair.
Thank you. Kim Leadbeater.
Thank you, Chair. I'll speak firstly, if I may, and I will keep my comments brief because we've had a very thorough discussion today. I'll speak briefly, if I may, to Amendment 123 from the Honourable Member for Broxtowe. Amendment 123 would change from an inevitably progressive disease to a typically progressive disease. Was that the next grouping? Oh, am I peaking too soon? Apologies, Chair. Peaking too soon. I'll come back to you, Honourable Member for Broxtowe. What I will do then, I will turn to the Honourable Gentleman for East Wiltshire. Amendments 399, 400 and 401 on the inclusion of medical conditions, which he submitted a few days ago before the end of recess. I looked at these amendments over the weekend, and I was very interested to hear his reasoning behind them today. And look, this is the purpose of committee. I've listened really carefully to what he's said, and he's made some really valuable points, Chair. I've taken the view all along that this legislation must not only be the strongest anywhere in the world, but it must also be very clear in its intentions, and it must leave no room for ambiguity over who is entitled to request assistance under its provision. I am very comfortable with the definition of terminal illness as is included in the bill. But across the world, and I've done lots of research into this, and I know other colleagues have, some jurisdictions use the term medical condition, or actually just the term condition, and others do not. Many in Australia do, but in New Zealand, for example, where they have a similar law to what is being proposed here, medical conditions do not feature, nor do they in a number of states in America. So whilst I don't necessarily think it would definitely be problematic to include the term, I appreciate the argument that he's made, and we have to be as cautious as possible to ensure the Act achieves its purpose but does not create a lack of clarity. And I think that point's been very well made. And the advice I've received from officials is that medical condition doesn't, as he suggested, have a clear legal definition and could therefore be seen as imprecise, and that does worry me. The purpose of the bill is clear. It's in the title. It's to give choice to terminally ill adults at the end of life. They must have a clear, settled and informed wish and be expected to die within 6 months in circumstances that are inevitably progressive and cannot be reversed by treatment. The Honourable Gentleman, I believe, has helped to make that even clearer, and I'm very grateful to him for doing so. It shows... Of course
I thank the Honourable Member for making points very clearly. One of the things that I want to ask her is, the last words of the Amendment 181 say nothing in this subsection results in a person not being regarded as terminally ill for the purpose of this Act if, disregarding this subsection, the person meets the conditions in paragraph A and B and of subsection 1. Doesn't this actually demonstrate that the amendment does not change the test for terminal illness?
Could I have apologies, Chairman? I'm speaking to amendments 399, 400 and 401. I'm happy to come back to that point at the appropriate time. But if I may just finish my comments on those amendments. As I said, the honourable gentleman has done a really good job this morning, I think, of improving clarity on this issue. And it shows, I would say, Chair, that the committee is doing its job and working effectively. And as such, I would be open to supporting those amendments.
Well, I'm delighted to hear it. Mr. Speaker, I'm very pleased to hear that, and I'm grateful to the Honourable Member for that and to other members who've indicated their sympathy for this amendment. So I look forward to the division, including to the Minister's decision. I just wanted to quickly follow up the point made by the Honourable Lady opposite to the Honourable Lady, and I don't know whether she'd like to intervene to help me understand this point, which is in her amendment 181. There's an indented subclause which states that nothing in this subsection. So this is the point about this is the redrafted clause 3.2, which states that that only because you've got disability or mental disorder does not qualify you. The additional sentence says nothing in this subsection results in a person not being regarded as terminally ill for the purpose of the Act. If the person meets the conditions in paragraph A and B. So does she not agree with me that that essentially means this clause does nothing? It confirms the terms of the eligibility set out earlier in the bill, and that you would still be eligible to receive an assisted death in consequence of a mental disorder, if you had conditions that were in consequence of a mental disorder or a disability. So I'd like her just to, I mean, if she felt like intervening on me, to help me understand what that additional sentence adds, because to my mind it actually negates the purpose of the clause. But
will the Honourable Member give way?
Happy to give way.
And I thank him for his intervention. I stand here as a disabled woman. Under this Act, as a disabled woman, by reason only of being a disabled woman, I would not be eligible to have access to assisted dying. So this amendment clarifies that by only being a woman who has a disability, I wouldn't be eligible. However, if I develop a condition which means that I have a terminal illness, which leaves me only 6 months left to live, I would be permitted to have that choice. And that's, I think, right that I should have that choice. As I said in my speech at the second reading, this is about giving people access to a good death and living a good death. And this is about giving that choice to disabled people where they wish to make it, whilst at the same time building in sufficient safeguards so that this is not something pressed upon them.
Order.
Thank you.
Order. Right. I started this, so I don't like to intervene when the debate's going on, but I did indicate earlier on, interventions have to be just that, not interventions, not mini speeches, not disquisitions. So please, can we keep the interventions short and precise, please? Annie Kruger.
I'm grateful, Mr. Chairman, and I thank the Honourable Lady for that intervention, and I recognise the force of what she's saying. And to be clear, the amendments that I am supporting would not deny disabled people any of the other rights that are being awarded in this bill. Of course, he's absolutely right that a disabled person with a terminal illness would qualify just as much as somebody who wasn't disabled. That's absolutely right. The purpose of the amendment is to ensure that people whose illness is the direct consequence, particularly of a mental disorder, would not be eligible. And the reference to disability is because of the confusion which I especially recognise in current law and guidance around where the distinction between disability and terminal illness lies. That's the concern that we've got. So the purpose of the amendments is to ensure that people will not be deemed as eligible for an assisted death in consequence of disability or mental illness. And I know that's what the Honourable Lady is trying to do with this amendment and with the clause that it amends. So we're on the same page. Our concern is that by including the words for the avoidance of doubt and the word only, we leave quite a large loophole through which, I'm afraid to say, some vulnerable people might fall. So, Mr. Chair, thank you once again. I look forward to the division on these amendments, and I'm sorry we haven't been able to discuss all of them in close detail, but I'm very grateful to members for the debate that we've had.
Okay. Amendment 399 proposed to clause 2 as on the amendment paper. The question is that the amendment be made. As many as that opinion say aye. Aye. To the contrary, no. I think the ayes have it. The ayes have it. Okay. We now come to Amendment 123 to Clause 2 in the same name in the name of Julia Campbell, with which we'll be convenient to consider Amendments 9, 48, 282, 51, 234, 10 and 402. I call Julia Campbell to move Amendment 123.
Thank you, Chair. This amendment changes the definition of what it is to be terminally ill from having an inevitably to a typically progressive illness, disease or medical condition that cannot be reversed by treatment. Something that's been repeatedly said and come up in oral and written evidence are the limits of medicine and where the limits of medicine manifest in our present healthcare system. The argument that our current medical care is limited has been used frequently by supporters of the bill. It's used to highlight the benefits of assisted dying by stating that even with the best care available, not everyone can be prevented from experiencing significant suffering as their life comes to an end. However, such an understanding of the limits of medicine is not consistently applied in the bill. The truth is, and this is something repeatedly corroborated within the written evidence, is that in many cases you simply cannot reasonably know how long a person could survive. Witnesses have explained that predicting whether someone is inevitably terminal is often not a certainty. So even when a disease is considered advanced or end of stage, there are variables such as an individual's response to a treatment, access to care, new clinical trials, or even medical intervention, or a person's overall resistance that can influence the outcome. When practicing medicine, doctors often use terms like prognosis, life expectancy, or expectation, rather than definitive statements on the degree of someone's terminal prognosis. These variables in prognosis make this amendment necessary. Typically, better acknowledges the limitations of the knowledge of medical practitioners. In written evidence submitted by Dr. Chris Paxton, a retired GP of 38 years, he says no doctor can accurately predict if a terminally ill patient has 6 months or more to live. I've seen many patients, he goes on to say, being told that they only have months to live and continue living for many years after their terminal diagnosis. The concept of a condition being typically terminal acknowledges that while a disease usually leads to death, there may be exceptions where individuals survive longer than expected or even achieve remission. The process of assisted dying must maintain this honesty and transparency with patients who are seeking assisted death. There is a declaration of certainty that is implied by using the word inevitably. In her written evidence, Dr. Ariel Dempsey, who is currently studying end-of-life care, says the following: physicians' prognosis estimates a variable. They're optimistic, they're pessimistic, they're uncertain, but more often than not, they are inaccurate. For example, in a prognosis of 6 months, a prognosis of 6 months is required for hospice eligibility in the USA. Yet it is not uncommon for hospice patients to live beyond 6 months, even without life-prolonging treatment. Using the word inevitably can lead to an over-reliance and overconfidence in the judgment of their doctors for individuals seeking assisted death. If someone believes without question that they will inevitably die within 6 months, an assisted death may seem like an obvious and a minimally life-limiting choice. The problem is that by claiming their very imminent death is inevitable within 6 months, it simply may not be true. Not only does the use of the word inevitable risk embedding dishonesty into our law, but it risks doctors who agree to engage in assisted dying, end-of-life care, becoming overburdened with the responsibility when it comes to proclaiming an individual's prognosis. A doctor, having considered the circumstances that surround a person's illness, can only give a prognosis that is typical, and typical indication of their life expectancy. By making this change to the bill, we make sure that individuals considering assisted dying understand that the doctor is enabled to provide with complete certainty on their prognosis. Prognosis is often not an exact science, and it can vary depending on numerous variables, including the course of the disease, the patient's response to treatment, and other unforeseeable factors. If we're giving doctors the essentially impossible task of proving inevitably that death will occur in 6 months, there is a risk of... I've almost finished. I'll carry on. If giving doctors the essentially impossible task of proving inevitability that death will occur in 6 months, there is a risk of an individual being advised to stop treatment, artificially accelerating them into a serious or seriously terminal state, or speed up to ensure their eligibility. As medical intervention is so key in the prognosis of a serious ill patient, it makes no sense to me to use language that is not consistent with real-life medical experiences or reasonably within the scope of medical diagnosis. Thank you.
Thank you. Amendment 1 to 2, 3 to clause 2, as on the amendment paper. The question is that the amendment be made. Rachel Hopkins. Rachel Hopkins.
Chair, am I speaking at the right time for Amendment 234?
Yes, you are.
Yes. Okay. I would like to...
Well, I'll take Tom Gordon.
Thank you, Chair. I give way to my own member.
Thank you, Chair. It's an honour and privilege to serve the new chairship. I am speaking today in support of Amendment 234, which is tabled under my name, which would seek to ensure that people suffering from neurodegenerative conditions are not excluded from the dignity and autonomy that this bill seeks to provide. The amendment extends the eligibility period for those with neurodegenerative conditions from 6 months to 12 months, a simple yet crucial change that could alleviate needless suffering and ensure fairness in our approach to end-of-life care. I'll explain exactly what the intention of this amendment is. It would change the law to match that in 5 of the 6 Australian states. The wording mirrors that found in those jurisdictions. Conditions affected by the change would be those such as motor neuron disease, Huntington's, multiple system atrophy, progressive supranuclear palsy, and Parkinson's, and many others too. Although Alzheimer's is a neurodegenerative condition, those would not be eligible for an assisted death should this amendment pass, because they would not have the mental capacity. We must recognise the reality of neurodegenerative diseases.
So within the Mental Capacity Act, obviously, thank you, Chair, sorry, those with early stage dementia or Alzheimer's could pass the Mental Capacity Act test. Does he agree with that?
They would need to be within the definition of a terminal illness. I'll come on to that point later on within the content of the speech. We must recognise the reality of neurodegenerative diseases, that there are other conditions where prognosis follows a clear trajectory. People with conditions such as MND, Parkinson's and others experience a slow but relentless decline. Their suffering can be profound long before they meet the 6-month prognosis requirement under the current bill. If we look at some of the real-life stories and take the example of Mary Kelly, a bright and sharp-witted woman from Middlesbrough. Diagnosed with Parkinson's last year, Mary knows that she faces many years of deterioration. She has said, and I quote, "It would make a world of difference to know that assisted dying was legal and available. I know if I'm not finding joy, I can end it peacefully. It would make the intervening years so much more peaceful, loving and relaxed." But Parkinson's-related dementia affects a third of those with the condition. If Mary loses capacity before a doctor confirms his eligibility, she'll be denied that very right that this bill aims to uphold. If we do not amend the legislation, people like Mary will lose their autonomy precisely when they need it most. We must also consider the experience of other people, like Phil Newby, who was diagnosed with MND a decade ago. Phil fought a challenge to the UK's ban on assisted dying, taking a case to the High Court in 2019. He is the last living person who took one of the court cases involving assisted dying. Phil knows that the uncertainty of prognosis leaves too many in limbo, and he said, "People with neurodegenerative diseases often suffer a cognitive decline in later stages. 12 months would give them a much greater chance for a civilised death to those suffering from the most devastating illnesses. We must make sure that those voices are not ignored during this conversation. Imagine a scenario where someone with MND applies for an assisted death. They tell their friends, family and loved ones. They begin to make preparations, including signing a written declaration. But they can't get approval until a doctor says they have 6 months left. They wait. Their condition gets worse, suffering choking fits, having feeding tubes fitted, and experiencing a slow and cruel deterioration. Then finally, receive approval from the first doctor. But before they can get to the second doctor, they begin to lose capacity. They're still suffering, their family know their clear and settled wish, that they have no chance of a second approval, especially no chance of getting approval from a panel. They will be consigned to a death of agony and pain, potentially, despite everyone knowing that this is not how they would like to die. Their family must watch on, helpless. The loss of competency is one of the greatest fears for those with neurodegenerative conditions. The bill currently states that a person must have full mental capacity at the time of their assisted death. It is an important safeguard. But we must take note that people who develop MND can have their decision-making impaired, and many, around 50% of those people with MND experience some form of cognitive decline. In New Zealand, where a 6-month limit exists, many people lose that decision-making capacity before they could proceed. In contrast, in Victoria, Australia, where there is a 12-month limit for neurodegenerative conditions, only 7% lost competency. If we do not amend the bill, we risk condemning those people to a fate they fought to avoid. We must almost recognise the difficulty in predicting life expectancy for those with neurodegenerative conditions. Prognosis is not an exact science, and I'm fairly sure everyone can agree on that. That's something that people across have made the point repeatedly. The Court of Appeal has acknowledged that a 6-month prognosis cannot be made with certainty for many terminal illnesses, and I think that is one of the most difficult things that we've had to grasp with as part of this committee. To impose what it could seem an arbitrary threshold on those with conditions is unfair and unnecessary in my view. Moreover, if we look at international examples, there are many UK residents who have to travel to Switzerland for an assisted death. Many of those do not have 6 months or fewer to live. If we end up in a situation where we have a 6-month limit, then we will still see people having to travel to Switzerland or other jurisdictions to ensure they have an access to an assisted death. And I worry how people in this country would see and feel about that, particularly those families who might wish to accompany their loved ones on that journey and the legal consequences that could follow. There is recent polling that shows 2/3 of Brits support an amendment that would allow people with neurodegenerative diseases to have access to an assisted death. We know that 85% of people living with multiple system atrophy gave their views in a MSA Trust survey to support this change in the law. This is not a minor or a niche concern. Every year, motor neuron disease kills 2,200 people in the UK. That's 6 people per day. 45% of people living with MND say they would consider an assisted death if it was changed. It's not a hypothetical scenario. These are real people making real choices about how they wish to live and how they wish to die. My amendment would not overload the system. Experience from overseas tell us that jurisdictions such as Victoria and other Australian states already have a system with 12 months for neurodegenerative conditions, and it works. New Zealand, which maintains a 6-month limit, have seen people unable to qualify, and they're looking at what they can do to ensure that there is greater access. We must listen to the evidence that we heard from the expert witnesses too, both in written and oral form. People like Professor Meredith Blake and Chloe First, who testified the importance of a 12-month eligibility period, not just for fairness, but for the practicality and allowing patients to navigate the process in time. I know that everyone here wants to see a bill that is about dignity, and if it's truly about that, then we must ensure that it works for those who need it most. It's not about opening the floodgates, it's not about refining a law to try and expand the criteria beyond, it's about ensuring equal access. I know that, having spoken to colleagues across the committee, that there is a lot of thought and consideration that's gone on to this, and with that in mind, I won't be pushing this to a vote, but I do think that it is important that those voices of people with neurodegenerative diseases are considered as part of this process.
Chair. It's a pleasure to speak under your chairship, and I rise to speak in support of Amendment 234, but I acknowledge the points raised by the Honourable Member for Harrogate and Knaresborough about not pushing this to a division, but the importance of actually hearing reasons why this would benefit the bill if it was. It would allow terminally ill people with neurodegenerative illness, disease conditions who have fewer than 12 months left to live rather than 6, the right to choose an assisted death. And I speak as a humanist because I'm very alive to many members of the public and some MPs wanting a wider scope of eligibility to cover intolerable suffering, with no timescales, in fact. Indeed, there's an amendment there. And I believe the proposal of this bill has had people speak to her to say the bill needs to go further. But like all of us, I want to make this a good bill, a good act that will have strong safeguards while allowing people choice at the end of life, but something that will command the support of the House. So I reflected on whether we need to have such a wide intolerable suffering clause, and in my reflections I thought that this amendment for 12 months for those with neurodegenerative disease would be a good way of reflecting the breadth of voices that we have heard from in the course of the debate on this bill. I think it's an appropriate compromise, and I think one of the things we've seen through the course of this debate on amendments to the bill in committee stage is the real pulling apart and the real consideration of what this means in practice. And so a 12-month timescale for those with neurodegenerative diseases is so well set out by the member who proposed the motion, means that people could make decisions while they still have mental capacity. And as he rightly said, as so often, their condition would see a cognitive decline before 6 months. The Motor Neuron Disease Association and other organisations supporting people living with terminal neurodegenerative diseases highlighted problems with that 6-month criteria and the inequity that obviously arises. And again, I was going to reference the medical practitioners from Australia, where in different states the assisted dying law does have an eligibility criteria where an illness, disease or condition is expected to cause their death within 12 months. So again, it's actually out there in practice. It's not just a new concept. And again, Professor Meredith Blake, during the oral evidence session, said Queensland legislation is different. It sets a 12-month period of expected death. And the reason for that approach was in response to feedback from people living with neurodegenerative disease that they felt that they were being put in a different position to people suffering from or experience other terminal illnesses. So while I just draw to a close, there's a personal reason why it's also something important to me to ensure that we try and reflect on this 12-month eligibility, and that's in relation to Diane Pretty. Diane Pretty was from Luton, albeit she lived in the neighbouring constituency, who some 25-ish years ago was diagnosed with motor neurone disease and tried to change the law then, so she could access assisted dying because the pain and suffering she endured because of her terminal illness. She said, which is fundamental and at the heart of what we are trying to do here 25 years later, I want to have a quick death without suffering at home surrounded by my family. And in the end, Diane Pretty was not successful, and she died aged 43 on the 11th of May 2002. She didn't have a choice. She could not choose the death she wanted. So much has been said about rushing this bill, but that was 20 plus years ago, and the debate has been going on for many years, and that's why I do speak in support of Amendment 234, so that those with neurodegenerative terminal illness, which is reasonably expected, with death which is reasonably expected within 12 months, can access an assisted death. Thank you, Chair.
Rebecca Paul.
Thank you, Chair. I'm going to speak to Ball 9 and Ball 10. Probably spotting the trend, I'm speaking in favour of a lot of the Ball amendments. These amendments ensure the bill does what it aims to do, ensure assisted death is only available to those who are genuinely at the end of life. Under the current Clause 2, a person is terminally ill if they have a prognosis of less than 6 months, and if they have an inevitably progressive illness, disease, or medical condition which cannot be reversed by treatment. This wording gives rise to a risk of unintended cases meeting eligibility criteria. In Oregon, conditions such as anorexia, diabetes, arthritis, HIV/AIDS, and hernias have all qualified for assisted death. That is partly because the Oregon law uses the language of irreversible, just as this bill says cannot be reversed by treatment. Conditions like diabetes arguably cannot ever be reversed, which suggests something more akin to cured. They can only be managed. So the definition of terminal illness is now broader than it was ever intended to be.
Will the Honourable Lady give way?
I will, of course, give way.
I thank the Honourable Lady for giving way. Prior to entering Parliament, I used to work for the Type 1 Diabetes charity. I feel like I keep saying this a lot recently. The point I would make is obviously, I think when we talk about diabetes, we often aren't considering the fact there are different types, including type 1, type 2 and gestational. They are not all akin and not all the same. And furthermore, the NHS in its own language, they refer to it as a lifelong condition rather than a disease or anything that's terminal. So, I mean, how would she reflect on that?
I thank the Honourable Member for that thoughtful intervention, and I completely concede it's not entirely clear, and there are different sources that describe it differently, which for a non-medical person like myself makes it difficult. So there are certain websites, NHS England, that may reference it as progressive, but equally I'm sure there are other sources that don't describe it in the same way. So I think you make a really good point, and you will see as I talk through and go through my speech, I quite often talk about things arguably be the case. So I'm not saying it definitely is, I'm just highlighting that there is a risk, because if people disagree on whether it's progressive or not, that's when we then have an issue. And I sort of see this as an opportunity at this point to try and tighten up any of that potential risk. So I would normally say the ordinary person on the street would not expect diabetes to ever fall within the definition of a terminal illness. Yet there is a risk that it could do for the reasons I've just explained. And that means the drafting of the clause is not quite tight enough in my view. So Amendment 9 and 10, Ball 9 and 10 are incredibly important. They are essential to ensure that those people who were... I will, of course.
Just before she moves on, thank you, Chair. We may actually have come to a very sensible position here based on the other amendments we've been discussing, 399, 400 and 401. I've just done a little bit of Googling, and diabetes generally is referred to as a condition. I mean, it might be referred to other ways as well, Chair, but maybe this would be another reason for us all to support amendments 399, 400 and 401.
I thank the Honourable Lady for that extremely good news, and that would definitely be helpful, I think, and give some reassurance if that improves the position here. Amendment 9 and 10, they are essential to ensure that those people who were never intended to be eligible for assisted dying under this bill are kept outside of it. Amendment 9 seeks to ensure that it's not just illnesses that can be reversed by treatment that are ineligible, but also those where the progress can be controlled or substantially slowed by treatment. So obviously diabetes being the classic case, it can be slowed and controlled by treatment. And Amendment 10 further bolsters by ensuring that treatments that improve prognosis are not disregarded under subclause 1, subsection A. The problem we have with the current clause 2 is that it fails to distinguish between those who are truly at the end of their life and those who only become terminal if they do not access treatment. There is no requirement for a person to be receiving medical care when their prognosis is assessed, which means that many manageable but irreversible conditions like diabetes, potentially, and chronic kidney disease could qualify as terminal if treatment is stopped. If we take the example of someone with type 1 diabetes, like my honourable friend, the member for South Northamptonshire, Sarah Ball, who put forward these amendments, if she were to stop taking her insulin, she might meet the criteria for terminal illness under this bill and qualify for an assisted death. I mean, I certainly hope she wouldn't. But without treatment, type 1 diabetes could arguably be an inevitably progressive and irreversible condition that would result in death within weeks or months. I will, of course.
There's nothing inevitable about a diabetic getting worse. They just need to take the right treatment. So the inevitable, I would say, is a key word in that. And I do respect the what you're saying about this amendment, and it does have some value. But I do think it's covered in the current language. Inevitably progressive disease, inevitably, which cannot be reversed. So it's inevitable and cannot be reversed. I think is enough of a protection, a safeguard, to make this a good clause.
I thank the Honourable Member for that intervention, and I know obviously he has a huge amount of experience with his career on that, so thank you for that contribution. And it must not be forgotten that the nature of such an illness is that there are periods of unwellness when these people may be at their lowest ebb, and it's our job to protect them from something in that moment in time that could sound appealing. So the crux of this issue is that this bill makes no distinction between a condition that is inevitably fatal and one that could be substantially slowed with treatment, subject to the points, obviously, that the bill sponsor has just raised around the improvements that we may well now see following the events we've just discussed. Absolutely.
I'm grateful, and she's making some valid points on this argument. I do, however, want to pick up from the honourable member from Stroud, because not only is it talking about an inevitably progressive illness, but it's saying one that cannot be reversed by treatment. And when we're talking about type 1 diabetes, and I think this is where my honourable friend is actually talking about opposed to other forms of diabetes, but type 1 diabetes, you either have insulin or you don't have insulin.
Can I also just ask members, forgive me for this, but interventions, as I say, should be pretty short, and they really should be asking a question of the member, not making a mini statement. So can people stick to that, please?
Forgive me, Chair. I will come to the point. If you don't have insulin, it can be reversed by administering insulin, which is the treatment for diabetes. Does she accept in those circumstances it would fall within this clause?
I thank the honourable member, another doctor, so thank you for that contribution. But I would suggest that it's not, it can't be reversed, it can be managed with treatment. So all I'm trying to do is to make sure that that piece is picked up. Because I think, again, we all agree that we wouldn't expect it to fall within the terminal illness diagnosis. No fewer than 15 clinicians and medical researchers have mentioned diabetes specifically in written evidence. Other conditions are mentioned too. For instance, 2 consultant physicians, Rosemary Anthony Pillai and DP Whitehouse, say that those on medication for heart failure could potentially qualify if they stopped taking their medication. And Dr. David Randall, a consultant nephrologist at the Royal London Hospital, sets out in written evidence the example of a young man who has benefited from a kidney transplant but stops his immunosuppression medication. This would lead to transplant rejection and likely death within a few months. So would that qualify him as terminally ill if we weren't to make these amendments? I will, of course.
I thank the Honourable Lady. The examples she gives, I think, speak to refusal of treatment, of life-preserving treatment. For example, the failure to stop insulin. That will inevitably lead to death, as it stands. So why does she believe that anyone in those situations would need to seek voluntary assisted dying?
Thank you. I thank the honourable member for his contribution. I think I'm sharing with you the content of written evidence. So people working in this arena, medical clinicians, the people I've just referenced, have taken the time to submit written evidence which suggests they do see a risk with this, and this is something that we need to think about. So I think you could well be, why would someone be seeking assisted death in that moment? But it's more about if someone technically qualifies, and obviously we've still yet to get through the bill, and there's lots for us to debate. So we want to just make sure that people aren't put on that pathway when they aren't actually terminally ill and their condition can be managed. People potentially are in a low place, and we need to be there to provide the support. And it comes back to some of the points I was making earlier about that balance with best interests. And I know it is really difficult to set that level right, but we also need to think about best interests and protect people when they might be at their lowest point. As I mentioned already, in Oregon, conditions such as anorexia, diabetes, arthritis, hernias have all qualified for assisted death. And not because they're inherently fatal, but because treatment was refused or unaffordable. And we also need to think about the situations when there might be supply chain issues with certain treatments. So there could be situations that arise that we just need to, that we might like to think wouldn't happen, but they could happen, and we need to think about what that means for this bill. And some lawyers and doctors in the US have advised patients on how to bypass the terminal illness criteria by refusing food and water until they become terminal, but I think we've talked about that quite a lot today. We already do have some evidence of this in practice. Take Cody Sontag, an Oregon woman with early-stage dementia. She had few symptoms and was not eligible for assisted death, but after refusing food and water for a few days, her doctor ruled that she met the 6-month prognosis requirement. Young women suffering with eating disorders are a group that I think it's important we carefully consider, but I appreciate we have spoken a lot on this today, so I will be brief. In Chelsea Roff's evidence, she set out that at least 60 people around the world have been euthanized or assisted in suicide with anorexia nervosa listed by name as a terminal condition. In 100% of the cases, the people were women, and a third were between the ages of 18 and 30, and 2/3 under the age of 40. She says, and I quote, "I have to emphasise that these were young women who did not have failing organs and did not have comorbid terminal conditions, and they had decades of life ahead of them." UK courts have already ruled that treatment can be withdrawn from young women with anorexia, acknowledging the likely result will be their death after doctors framed their condition as terminal or untreatable. So I think these examples powerfully demonstrate why it's vital these amendments are accepted, so that the result of these conditions does not result in a person qualifying for assisted death if it can be managed sufficiently with treatment. In oral evidence, Dr. Miro Griffiths asked us, what constitutes 6 months left to live, particularly if you are engaging with technological devices, medical assistance, and so on. For example, I have a progressive condition that continuously makes me weaker and has respiratory complications, and so on. If I remove the ventilator that I use at night, if I remove my other medical devices, and if I stop my engagement with therapeutic services, does that constitute me having a terminal illness? Because my rapid acceleration towards death becomes more evident. In written evidence, Pathfinder's Neuromuscular Alliance warned that for those with conditions like muscular dystrophy, access to treatment is essential. And they say, I quote, "It would not be unreasonable, therefore, to suggest an individual with neuromuscular respiratory failure could die within 6 months, and yet they might also live 20 to 30 years. In written evidence, a group of leading physicians and researchers, including experts from Johns Hopkins and the Royal College of Psychiatrists, say the bill's definition of terminal may not adequately distinguish between a condition that is inevitably fatal and one that only becomes terminal with adequate care. They add, under this bill, patients with incurable but treatable conditions could become terminal if they are unable to access timely treatment or choose to forego life-sustaining care. It is therefore vitally important that the definition of terminal illness is tightened to avoid unintended consequences. These amendments would ensure the bill applies only to those who are genuinely at the end of life without prospect of recovery, and I urge everyone to give consideration to accepting them. Thank you.
Thank you. Sharp.
Thank you, Chair. I'll be speaking to, in the first instance, 9 and 10, and then 2, 3, 4, and then my own 48 and 402, if that is okay. Thank you. The Honourable Member, I hope it's in order to note that the Honourable Member of South Northamptonshire and the lady before has already mentioned herself is a type 1 diabetes sufferer. These two amendments both concern matters of which she has a personal understanding. This amendment would mean that illness, disease or medical condition, etc., the progress of which can be managed or controlled by treatment, are not characterised as terminal illness. The first of these three amendments is number 9. It says that instead of saying the illness that a person suffers that cannot be reversed by treatment, the bill should say that its progress cannot be controlled or substantially slowed. This amendment is clearly a most important one. It seeks to prevent illnesses which can in fact be treated effectively are not classified as terminal illnesses. And this amendment would work to mitigate two very serious risks posed by this bill. Firstly, it would make it more difficult for someone who, for whatever reason, wished for an assisted death to qualify for that process by failing to follow a reasonable course of treatment. I do not say that the amendment would make it impossible for anyone not to do so, but it is an important safeguard. Amendment 9 would also provide safeguard against the expansion of those conditions which would qualify people for assisted death. My honourable friend for Spen Valley and members of this committee have repeatedly praised the Oregon law, but we do not want to follow that example in every way since we know that in Oregon, sufferers from anorexia have been able to access assisted dying. Again, I do not say this amendment would make it impossible to expand the list of conditions, but it would make it harder. My honourable friend for Spen Valley has said repeatedly she wants to see this bill as the strongest safeguards of any assisted dying bill in the world. For that reason, I would hope she will join me in voting for Amendment 9. The second of these amendments, number 10, is necessary to ensure that the bill does what it is intended to do, that is, to provide assisted death for those who are truly at the end of life, not for those with treatable conditions who may ask for assisted death in a moment of perhaps personal crisis. As it stands, the bill allows a person to qualify for assisted death if their condition is likely to cause death within 6 months, but it does not specify whether that prognosis assumes they are receiving treatment or not. This is a dangerous oversight. It leaves the door open for individuals with irreversible but treatable conditions such as type 1 diabetes or HIV to be deemed terminally ill simply because they stop treatment. If someone declines of a cause of aggressive chemotherapy, that will have considerable side effects, we all understand. So a declining of a treatment and drugs for another illness is not different. There are many other examples. For instance, around 5 million people in the UK are on statins preventing heart disease and stroke. If they were to stop their medication, then many would move faster into the terminal phase of their disease. Another example would be cystic fibrosis. If people either stopped taking their medication or stopped their physio, they would actually be in scope. It is the same for all life-sustaining medication. So if we accept the principle that someone has a right to refuse treatment which clearly has been established, then there are no protections within this legislation to prevent them from being eligible for an assisted death. The scope of this bill, then, is so broad. These chronic respiratory, cardiovascular organ failing illness do have an impact on somebody's psychological condition as well. So I will be supporting that amendment. Moving on to 234, Chair, if I may. I'd like to speak in opposition to the amendment tabled by the Honourable Member for Harrogate and Knaresborough. This amendment weakens what safeguard the current 6-month prognosis requirement provides. I regret to say it does so by expanding the definition of terminal illness to include neurodegenerative conditions with a prognosis of up to 12 months. The bill has not yet passed, and already there are efforts to widen its scope. When my honourable friend for Spen Valley first brought the bill before the House, she repeatedly underlined the importance of a 6-month prognosis. Speaking in the second reading debate on November the 29th, my honourable friend said, "As such, the bill is not about people choosing between life and death. It is about giving dying people with 6 months or less to have autonomy about how they die and the choice to shorten their deaths." My honourable friend for Penistone and Stocksbridge also underlined the importance of a 6-month prognosis in the second reading debate. She said the choice of assisted dying is one option for adults when facing 6 months terminal illness. Must be set alongside the choice of receiving the best possible palliative and end-of-life care, or it is not a choice, no choice at all. Absolutely.
Just for clarity, I will not be supporting that amendment.
I agree with those sentiments from the Honourable Member for Spen Valley and from Penistone and Stocksbridge. The choice of I agree with those sentiments very strongly, and I hope we can later return in this committee's proceedings to the state of palliative care in this country. But I do want to underline that the 6 months prognosis was not some minor detail at the second reading. Rather, it was a central plank of the arguments made by those who argued that we should consider passing this bill as it had safeguards that were the toughest of any assisted dying law in the world. It is less than 3 months since my honourable friend spoke those words, and yet we are already discussing an amendment that would remove the 6-month prognosis.
I thank you for giving way, Chair, and I think we need to be very fair to the Honourable Member for Harrogate and Knaresborough, who has said he won't push this amendment to a vote, and indeed if he did it wouldn't be something I would support for the reasons that she stated. But I actually also think we need to give him credit for making sure that the voices of people with neurodegenerative conditions such as MND, Parkinson's and Huntington's are heard, because they are an important part of this debate, whatever our views might be on the tightness that is needed within the bill.
I thank the Honourable Member and the previous Honourable Member for making their positions clear that they won't be voting for this. And I indeed share the Honourable Member's views in thanking the Honourable Member for bringing an amendment which does discuss these issues. However, I also feel, whether it's withdrawn or not, the fact is that this was an amendment that we are debating and we are going to be talking to. The Honourable Member for Harrogate and Knaresborough, whose amendment this is, no doubt feels very strongly, indeed the conditions of patients with neurodegenerative diseases make a case for relaxing the 6 months prognosis to 12. And I think there may well be a good case for doing so. But we can only consider this case for extending the prognosis to 12 months because of the challenges created by neurodegenerative diseases if we have first considered that extremely complex subject. We can't say that we as a committee have studied the difficult subject of neurodegenerative diseases and how they would affect the administration of assisted dying bill. We haven't heard from witnesses on this subject and we haven't been able to ask them questions. And when we did solicit written evidence on whether neurodegenerative diseases would affect the ability to self-administer lethal drugs, we haven't had time to study such written evidence. I appreciate he's not going to push it to a vote, which leaves some of this, what I wrote earlier, obsolete. We are sent here, I appreciate the Honourable Member's efforts, we are sent here by our constituents to represent them to the best of our ability. And I certainly try to do that. I know my Honourable friend from Spen Valley certainly always tries to do that. I have no doubt that Honourable Members from Harrogate and Knaresborough and all the other members are trying to do that. But if we are to represent our constituents, had this gone to a vote, then I would not have been able to support it, simply because we can't make those difficult decisions without being properly informed, and we can't make our minds to change the bill because of complex set of diseases.
Just a quick point of clarification, because actually I do remember asking one of the witnesses at our oral sessions about this very issue. Actually, it was Sir Nicholas Mustine, the esteemed judge who's also written and spoken about this extensively. We did actually ask about his views around neurodegenerative disease and extending the time to 12 months. And it was something that we were aware of and did discuss at the committee as well. So it's not completely out of the blue, in fairness to my honourable member.
I thank the Honourable Member for his comment, and I agree that we did, but we didn't hear from experts on the face of this bill at that point. It wasn't discussed. So whilst I acknowledge his point that we did speak to Sir Nicholas Mustine, we did not have further evidence, and this wasn't on the face of the bill when we took that evidence from those witnesses. So I'm pleased that other members will be rejecting. Have to give it.
I find this a little bit sort of baffling because we didn't listen to, we had a really comprehensive list of witnesses which we were able to sort of circulate in advance. It was one of those things, I think, that for all intents and purposes we cannot. I think the way and the format in which we all evidence sessions were held was really helpful and informative. We were able to ask questions, and as the Honourable Member has mentioned over there, that we were actually interacting with people and families. We heard from I think it was Pat who gave oral evidence as well, about his sister who had to go to Dignitas. So again, it was not something that was just a small amount. We did actually have a number of people bring this up. I just wondered if she could reflect on that. Thank you.
I thank the Honourable Member for his intervention. The crux for me certainly is that during the second reading debate, when this bill was voted, many members in this House cited one of the central planks to the debate at the time was the 6 months, and this would then have increased that to 12 months. And as I said, my concerns are that we're only 3 months in from that conversation, and we're already trying to expand it, which is why I wouldn't be supporting it. And I think I've said quite a bit on that, so I'll leave that for amendment Amendment 234, and if I can now speak to Amendment 48, Chair, if I may. So this is my own amendment which I tabled under the current wording of the bill. A person is terminally ill if their death can reasonably be expected within 6 months. My amendment would change that so that to be considered terminally ill, a person's death would have to be expected with reasonable certainty within 6 months, even if the person were to undergo all recommended treatment. One of the risks which confronts this bill is that of misdiagnosis. This is not some remote possibility, and let me go into detail. As honourable members know from the evidence brought before this committee, prognosis is not a precise science. Even with physical illnesses, determining life expectancy is highly unreliable. Government data from the Department of Work and Pensions reveals that 1 in 5 people given 6 months to live are still alive after 5 years. A study spanning 16 years found that doctors wrongly predict how long terminally ill patients will survive in half of the cases. Out of 6,495 predictions that a patient would die within 6 to 12 months, more than half, 3,516 to be precise, lived longer than expected. If the government itself cannot accurately determine terminal illness for benefits, how can we rely on such predictions to justify ending lives? Studies cited in written evidence submitted to this committee have found that clinicians are routinely inconsistent and inaccurate in their prognostic assessments, often underestimating survival. Professor Catherine Sleeman, a palliative care specialist, has underlined this point in her evidence to the committee. Doctors face considerable difficulty in prognosing whether somebody is in the last 6 months of their life. Professor Sleeman cites studies based on large samples of patients for whom doctors prognosed life expectancy. The studies found that 47% of the patients whom they predicted had 6 months to live, in fact lived for longer than that, in some cases for a considerably longer period. I would argue that there is a danger in using the standard of prognosis currently in the bill. The current research into doctors' prognosis indicates that almost half of their estimates that a patient has 6 months are incorrect. We clearly do not want people to choose assisted dying on the basis that they have only 6 months to live, when a very high proportion of them will in fact live longer. And if they are not given assistance to die, by taking a lethal drug or drugs. What my amendment would do is hold doctors to a higher standard of certainty. Under this measure, they would be explicitly held to prognosing that death would occur with reasonable certainty within 6 months, and that this would be true even if the patient underwent all recommended treatment.
Well, the Honourable Lady,
happy to give way.
I'm grateful for my honourable giving way. One of the reasons I think this is actually really fundamentally important, and I think we all accept that prognosis is quite difficult, but one of the reasons that this is important is I'm drawn to a member of my own specifically Labour Party, actually, who was given a diagnosis in 2012 of 12 months. Last year they were out delivering leaflets for me in the general election. That's why this is so important that we make sure we get this right. I'm sure that the Honourable Lady has examples of her own. Is that what's guiding her in pushing this amendment?
I thank the Honourable Member for his intervention. It is absolutely what's guiding. We know, I know many, I'm sure we all know people who are told they've got 6 months to live and they've lived a lot longer. We've heard stories of people living beyond 20 years who were told they had 6 months to live. There's lots and lots of real tragic cases where we've heard, like in the world of Dr. Miller, that would really, really benefit from this bill and something available to them. But equally, there are others, other families who actually have survived, their loved ones have survived, and not just survived, but actually thrived for years and years, years and years. In fact, a close friend of mine who happens to be the constituent of, the constituent of the Spen Valley MP, was diagnosed not to live very long, and 18 and a half years. It was quite an emotional time, actually, because her daughter's now old, to say she's still alive and well and thriving. Happy to give way.
Thank you, and I must admit I rejoice in these stories because they're fantastic that these things can happen. But should we just outline exactly how this bill will work? If you're given a prognosis of 6 months by a doctor and you decide that you want to have
Again,
Sorry,
can we
would you not accept, can I carry on like that? Would you not accept that actually the way this bill will, will the Honourable Lady not accept that this bill will work in a way that people may register for it, but they will only actually do it when their death is close? And therefore, if they get better and they live longer unexpectedly, they will then not take their lives. Thank you. Sorry, Chair.
Thank you, Honourable Gentleman, for his intervention. Actually, there's nothing in that bill that suggests that, because we can only imagine, we can only try and empathise as much as we possibly can with any person who's been given a diagnosis of 6 months to live. And they might, in that 6 months of process, might not wait. And it's like the Honourable Member himself, the good doctor, has said, this is about autonomy. They might not wait till they get to a position where there's lots of suffering. They might not wait to see that 6 months out. They might decide they don't want to take that risk. And actually, they might have lived another 15 years. They might have lived another year. They might have lived another 2 years. That's the point of this amendment. The point of this amendment is happy to give way to
I think she's making a really powerful speech, and it's good to have this debate. I think I would just ask her opinion on two things. One would be, as the Honourable Member for Stroud has alluded to, the research around the world shows that actually sometimes between 30 and 40% of people who sign up for an assisted death never actually do it, and that can be because they do get better, or the treatment makes their condition manageable, or they have a death in a different way. So I'd be interested to know her thoughts on that. And I think also, the other thing to point out is the number of people who sadly we know are taking their own lives because they're terminally ill at the moment. And again, I would go back to the point that I make quite regularly. No one at the moment is monitoring that.
Order, please. No. As I said before, these are interventions which are seeking clarification. They're not mini speeches. Nasha.
Thank you, Chair, and I thank the Honourable Member for her intervention. So if we take the 30-40% note, and if we take and she might correct me if I'm wrong, happy to be corrected, if there's about 600 people on average going to Dignitas, for example, for maybe... Sorry, would you like to...
Yes, sorry, just to clarify, my understanding is that it's between 6 and 7 people who actually take their own lives. So it's suicide.
Nasha.
Thank you. So if we take that number, and that 30-40% who don't take that, that's maybe a few hundred people. But the truth is, from this Dr. Sleeman's evidence, we're talking about thousands of people that are misdiagnosed every single year. And she was talking about 3,516 that lived longer than expected. And yes, I recognise and I value her comment about the 30-40% of them don't take that. But we also, perhaps not for this, I'll move on to the next amendment when I'm talking about that. But there is also that risk, and I just feel if we're going back to what the bill sponsor's intention is, to make this tighter, then surely this is a safeguard that she would support, just to ensure that we aren't missing, just to ensure that we are making it tighter as much as we possibly can.
Would the Honourable Lady give way?
Happy to give way.
Can she just clarify for me, can the Honourable Member just clarify for me what she means by reasonable certainty and how that differs from the clause as drafted, and why in her amendments normal language around the burden of proof is not used, such as on the balance of probabilities or beyond reasonable doubt?
Thank you. I thank the Honourable Member for his intervention. It's not an issue for a tribunal where it would be balanced probabilities. It's not an issue for a court of law. It's not a criminal court where we'd be using the proof beyond reasonable doubt. That's the issue. What I'm trying to demonstrate here is that doctors can make, in those diagnoses where they do get it right, they have much more certainty. So there might be that people have 6 months to live because they've got different types of cancer. So some types of cancer, having spoken to people, and I'm I'm certainly not a clinician or an oncologist. But what I do know from the evidence that we've had in speaking to people, some people have their disease, and the specialists know better, have a trajectory of plateauing out, right at the end dropping. Some have a jagged kind of decline. Some of those diseases can be predicted much more with much more clarity than others. So on the surface of it, somebody in September, it's a case that is actually within the Times. The lady who was told she wouldn't have more than 6 months to live. She was the founder of the Music of Black Origin Awards. I was with her last week. She was absolutely fighting, you know, and she wasn't supposed to make it to that day. So I think it's for the medics to decide. That's not for me to decide. But I would certainly like to. What that would look like for me is medics having much more certainty than they currently do. So we wouldn't have the 47% misdiagnosis. That's what I'm trying to get to. I thank him for his intervention. Coming back to it, I argue that there is still a danger in using the standard prognosis currently in the bill. The current research into doctors' prognosis indicates half of their estimates that they are incorrect. What my amendment would do is hold doctors to a higher standard of certainty. Under this measure, they would be explicitly held to prognosing that death would occur with reasonable certainty within 6 months, and that this would have to be a true even if the patient underwent all recommended treatment. I think that going back to the member's intervention, this is about raising the bar for how we make these decisions, how our medics make decisions. This is, I submit, a stronger test than the current one included in the bill. My honourable friend for Spen Valley has frequently stated that she wishes to create a bill, again, with the toughest safeguards in the world, and I keep coming back to that because the whole purpose of speaking to all these amendments is to put in opportunities. All these amendments are, by their very nature, members concerned to try and strengthen this bill. And through this amendment, it would tighten the prognostic standard required of doctors, that they would contribute towards tightening the bill safeguard, and I do hope members are able to support it. Finally, Chair, moving on to 402. There's going to be repeating a lot about anorexia once again. And I think it's very important because it's a very important amendment. For this amendment, the reason I've tabled this is a very simple but extremely important issue and purpose. This is to prevent people from qualifying from assisted dying by stopping eating and drinking to the degree that they develop severe malnutrition, such that a doctor would give them a prognosis of 6 months to live. The amendment aims specifically to protect people with severe eating disorders, including anorexia nervosa. It will also protect other people with a severe wish to, as one of the psychiatrists who testified before this committee put it, hasten death. I would hope my honourable friend for Spen Valley would be able to support this amendment, as would all other members of this committee. Make no mistake, this bill, as written currently, has a horrible loophole, and one that all of us should seek to close. We know that anorexia sufferers and other people with eating disorders can and do stop eating to the point where they are dying of malnutrition. If we allow these people to qualify for assisted death, unfortunately, this is not a hypothetical danger, it is happening. We know from this committee's own evidence where it's happened in other countries. A group of 8 experts on eating disorders submitted written evidence to this committee some weeks ago. That evidence submission is number TIA B54. The experts included Chelsea Roth, who's been referred to many a time in this bill committee, who gave very clear testimony before the committee, as well as 7 medical doctors from hospitals in the UK, the US and Canada. I would hope all members of this committee have read the evidence, but I would understand if they haven't, because we've had nearly 400 pieces of evidence to go through and very little time in which to read it. But it does seem to me that if we are trying to write the best possible bill with the strongest possible safeguards, then we have to pay the written evidence of experts the attention that it deserves. In their written evidence, the group of experts said, and I quote, "Patients with severe eating disorders frequently experience profound psychological distress and may express a desire to die. Whilst this may appear to reflect a clear and informed wish, it is often a symptom of their psychiatric condition which is remediable with appropriate treatment." These experts found that at least 60 patients with eating disorders have received assisted death in several jurisdictions worldwide, including the US, Canada, the Netherlands and Belgium. I stress the phrase "at least 60" because we cannot be sure entirely that this is the full total. It is sadly the case that some jurisdictions are much more painstaking and transparent in the data they publish on assisted death than others. In itself, it is tragic that people died in this way, but two things surely make this fact even worse. There are certainly men with eating disorders, but this is a problem that disproportionately affects women and girls. We know that the incidence of anorexia nervosa is much higher among women than among men in every age group. This is tragic. We also know that in every case where we know of a person with an eating disorder receiving an assisted death, that person has been a woman. And I say it again, we cannot allow the bill as it is currently written to stand. The Labour government was elected with a mandate to reduce violence against women and girls. We surely cannot pursue a goal that, whilst at the same time increasing the vulnerability of women and girls who have eating disorders. There is nothing in this bill as it currently stands that would stop doctors from signing off on assisted death from someone who had starved themselves into malnutrition. The courts in England and Wales have already begun accepting that some people with anorexia have reached a terminal stage. In the Court of Protection case, the NHS Trust versus L, which took place in 2012, a 29-year-old with severe anorexia was described in the ruling as follows. The prospects of her recovery overall approach zero, given that it is extremely unlikely that Miss L will recover from her anorexia. In best interest to move to palliative care if L is terminal stage of her illness. In that, and I know my honourable friend raised the issue of the Court of Protection from North West Hampshire. There are 10 cases where the Court of Protection have made rulings. In them, only one of those cases in 2012 was ruled upon where the young lady could be force-fed. In all...
Order.
Sorry.
Not sure.
Thank you, Chair. So I have it on evidence and I'm happy to provide the reference. Yes, happy to.
Well, I'm happy to say that, but my understanding is the other way around. In all but one, force feeding was decided by the court. And in the one that she's referring to in L, the court did wrestle over this particular issue and realised that such was the advanced stage of the patient's condition and the complexities of force feeding that they couldn't quite bring themselves to authorise it. But my understanding is that all bar one case, force feeding has been authorised.
I thank the honourable member for his intervention. Actually, it was the other way around, the court cases, and I'm happy to provide a reference to him. 9 cases, all of them found lack capacity, but still not in the best interest. Only one of them girls was 19 years old. So the courts decided, the judge found that they lacked capacity to make decisions about their treatment. The question of whether they had the capacity to decide to end their life is completely different, and it's not something we've asked for judges to hear before, judges to rule on. And the judge's ruling clearly implied the capacity to refuse force feeding even if it resulted in their death. And I'm happy to provide the references of that. So it was against the best interest to feed them. And tragically, in those cases, the judges in all 9 of those cases of the 10 accepted that this would lead inevitably to those young girls' death. My honourable friend for Spen Valley has repeatedly stressed that her bill is modelled on the Death with Dignity law in Oregon. She has stressed... Happy to correct that.
I actually haven't said that.
Order. This, with the greatest respect to members, this isn't a dialogue, this is a debate. It's not a chit-chat, it's a very serious issue, and interventions of that nature are not helpful. That's sure.
Thank you, Chair. Happy to correct the record. Happy to correct the record.
Point of order.
Point of order. If something is said which we know not to be correct, what should we do, Chair?
Well, I think that's going to be ultimately a matter of opinion, but if the Honourable Lady wishes to stand up and ask the Honourable Lady a question and get clarity from her, that's fine. But we're getting to the stage where this is becoming a dialogue. People are saying things, people can't hear what's being said, and I want this to be run in an appropriate fashion. We do have rules of debate in the House, and I'm trying to apply them. Otherwise, there lies perdition and chaos. Nice shot.
Thank you, Chair. I'm happy to withdraw that comment, given the member's intervention, and I welcome that intervention. She has stressed that most of the assisted deaths of people with eating disorders took place in the Netherlands and Belgium on intervention, certainly directly to myself in the last Bill Committee. The survey that Ms Roth and her colleagues carried out did indeed find that the Netherlands and Belgium had more assisted deaths of people with eating disorders than Oregon, but it also found that Oregon itself had more than one such case. California and Colorado have also accepted people with eating disorders as subjects for assisted death. I will just remind the honourable members that Oregon has had a considerably, and I referred to it earlier, it has a considerably smaller population than England and Wales. In 2023, the last year for which we have full data, Oregon had a population of just 4.25 million. England and Wales, by contrast, had a population of 60.85 million. That is over 14 times higher. Perhaps it is indeed the case that Oregon has had 2 assisted deaths for people with anorexia, anorexic sufferers. As one of the witnesses before this committee said, in England and Wales, we have 14 times the population of Oregon. If it became legal for anorexia sufferers in an advanced stage to take their lives under assisted dying, we would almost certainly have many more cases. Happy to give way.
Thank you, and thank you, Chair. I'd just like to ask the Honourable, does she not believe that an eating disorder is not reversible? Is that what you're saying?
Sorry, can you just repeat that?
Well, in this Act, if you have a treatment that can be reversed, you wouldn't be appropriate for assisted dying. So I'm just wondering whether you're saying that eating disorders are not reversible.
I thank the honourable member for his intervention. Absolutely not. That's not the point of what that's not the point I'm making. Eating disorders are reversible, but we have found that people who, if they decide, and this has happened across the globe, where this kind of legislation has been legislated on, it has been found that somebody who decides not to eat, who has anorexia, decides not to eat, then falls within the scope of assisted dying because it becomes a terminal illness. Happy to be.
I'm sorry, I didn't want to cut her off. Thank you, Chair. I didn't want to cut her off further, but I just wanted to echo the point. And, to the Honourable Gentleman's point, because he's made it before, we've exchanged this point. I really did refer him to quite a lot of research now that's showing how people in the UK, being treated by the NHS, are having a diagnosis of terminal anorexia. It is happening. And I refer the Honourable Gentleman to Professor Agnes Ayton, to the campaigner Hope Virgo, to the APPG in this place that's looking at that. And the fact is, it seems bizarre to us, because of course you can stop eating, you can resume eating, but the fact is that anorexia is treated as a terminal illness in parts of the NHS today.
Thank you. I thank the honourable member for his, and I concur with his remarks and his intervention.
Sorry, could I? Would you mind? Actually, terminal states of eating disorders is there's a lot of debate whether they actually exist or not. So I don't think that you can say that they're a real thing in that way. Some people in the profession think they certainly don't exist. So I would contest that. So thank you. Sorry, that's a statement.
I thank the Honourable Member for his intervention, but the truth of the matter is we have 10 cases that have gone to the Court of Protection. In those 10 cases, 9 of them cases are where the judges have ruled that the people, women, girls, one was only 19, did have the capacity not to take treatment. Happy to...
If I could just... I'm grateful, Mr Chairman, I'm grateful to the Honourable Lady. Just to clarify, what I said earlier was slightly incorrect in that I misread my, my briefing. Essentially, in those cases, as I understand it, I wonder if she'd agree, as I understand it, while she may be right that the court decided not to proceed with force feeding, a number of those applications were by the individual to stop force feeding. And while the court decided that on balance it was the right thing, in all those cases since 2012, the individual was not found to have capacity to make decisions about their own condition, and the decision was made by the court for them. That means that under the terms of this bill, they would not therefore qualify, because I think in all those cases, as I say, while they, and some of those cases are quite complicated, forgive me, Mr Chairman, some of those cases are quite complicated, a number of them, as I read it...
Order.
Sorry, I was trying to be pithy.
Order, right. There's an issue to some extent here of repetition, and Standing Order 42 gives me the power to stop these potential repetition. I don't want to use that. I don't want to interfere with the debate, but I'm afraid it's getting to the point of repetition, and if I need to invoke Standing Order 42, I will. Nasha.
Thank you, Chair. My understanding, and I thank the Honourable Member for his intervention, my understanding, the judge found that they had lacked capacity to make decisions about their treatment. The question of whether they had the capacity to decide to end their life is a completely different test. And I apologise in advance for repeating this, but the test isn't something we've tested, and they did have the capacity to refuse to be, and then the judge said they could not be force-fed. He ruled that they would inevitably, in 9 cases, tragically, it was found that these young women would ultimately, this by force, not force-feeding them, it would lead to their death, but insisted that force-feeding would not be in their best interest. So that's what happened in those cases. Happy to give that.
I mean, I stand to be correct, but my understanding in the seminal case which she's talking about, the case of the hospital versus L, the court decided not to force feed because the prognosis was that by force feeding they would perpetuate her death.
It is a case that I've talked about. If I can just go back to it. If I can just make some more weird, I might come back to that point, but I do thank the Honourable Member for his intervention. Yes, so just coming back to that point, the prospects of a recovery overall approach 0, given that this is extremely unlikely that she will recover from her anorexia, in best interest to move to palliative care. So she did move to terminal illness. So that, in some ways, actually makes my point for me, that she did move to being diagnosed as terminally ill. And that's what I'm trying to... The purpose of this amendment, from my perspective, is to close that very loophole that she would not... The majority of these cases are young girls, young people, young women. And those women, I don't want them to get to a stage where they qualify for this bill because they have a terminal illness because of them refusing food. That's what I don't want. I don't want them to qualify for this bill because if it can be treated. And that's the point I'm trying to make. Let's say, for example, there'd be only 1 or 2 assisted deaths of anorexia if this bill became law without my amendment. I would hope that every single member of this committee agrees with me when I say that even 1 such death would be unacceptable. Perhaps someone would say, oh, but we must not make the perfect the enemy of the good. And that has been said throughout this debate, or sentiments have been expressed in reflection of that very sentence. That's a good argument to make when we're trying to persuade our teenagers to finish their homework for school, etc. It doesn't wash for me when we're trying to create a bill with the strongest possible safeguards for vulnerable adults. Another thing I struggle with is about the perfect is the enemy of the good line, is it's too close to the argument in favour of brutal actions across the globe at times. We say things like, to make an omelette, you've got to crack a few eggs. I don't see us making, if we want to make this bill as best as possible, then those arguments can't be the ones that we use. It is not that perfect is the enemy of the good. Perfection is absolutely what we should be pursuing in this bill committee. We can't, just like the evidence that we heard in the evidence session, the idea that, particularly the witness who referred to, I remember being, I was aghast really, the idea that these 2 people who died in Oregon were somehow a red herring and there were only 2. It was really, really, really disappointing. I was extremely angry actually at that comment, because that's not something that we should be doing. That's not the standard we should be setting. So we can't be saying that. There's nothing good about letting people who've sadly reached an advanced state of malnutrition being given assisted dying. Surely we can agree on that. If this bill does not include my safeguard, it will do 2 things. Firstly, it will increase the dangers of anorexia. People already develop anorexia to such a degree that they perish of malnutrition. Allowing such people to apply for assisted dying will mean that the more severe anorexics die. And if we do not adopt my safeguard, we run a further risk that those who are not anorexic but wish to hasten death stop eating in order to qualify for an assisted death. Both of those things would be truly malign. I would hope all members of the committee will accept my amendment to protect those who would otherwise be at risk of starving themselves to an assisted death. I also want to bring the committee's attention to a letter that has been released this afternoon by nearly 40 individuals who work in the field of anorexia, eating disorders. And particularly, they have said, and this is a public letter, what they've put out today, and what they've said in relation to amendments is that this amendment that I'm speaking to particularly, this amendment states that mental illness does not qualify as a terminal illness, but as the legal text, in brackets, nothing in this subsection, makes clear it has no effect beyond restating that the condition must meet the requirements of clause 2, brackets 1. If a doctor holds that a mental illness meets the test in clause 2.1 for terminal illness, this amendment will do nothing to prevent that. Eating disorders are treatable. They are life-threatening when left untreated or poorly treated, but this risk is preventable. The deaths from eating disorders are not inevitable. As campaigners, clinicians, charities and organisations working with those affected, they urge this committee to take these concerns seriously and ensure this bill does not put people with eating disorders at risk of premature death under the guise of assisted dying. They further say, in regards to Amendment 402, Chair, which my amendment, and 48, the 402 explicitly states that a person cannot be deemed terminally ill because they have stopped eating or drinking. And 48 clarifies that a person is only considered terminally ill if their death is reasonably certain within 6 months, even with all the recommended treatment. So we are supporting those amendments 9, 10, 48, 42 and 11. And on that note, I will finish. Thank you very much, Chair.
Sarah Alding.
Thank you, Chair. I just very briefly want to speak against Amendment 234 in the name of my honourable friend, my good friend, the member for Harrogate and Knaresborough, but I will keep it brief because I know he's not going to press it to a vote. Just to say firstly that the bill that was passed, that was voted on at second reading, was a bill for terminally ill adults in the last 6 months of their life. So to be attempting to amend the scope of the bill in committee, I don't believe is what the House has asked us to do. I think the House voted for a bill that was specifically for people within the last 6 months of their life, and so to be amending it although I accept he's not pushing it to a vote. I don't think that's in order. The second point I wanted to make was to reflect on the evidence of Professor Sir Chris Whitty, the oral evidence that we heard as a committee, about how difficult it is to determine when somebody is within 6 months of the end of their life, and how much more difficult it would be to determine whether someone is within the last 12 months of their life, notwithstanding there's a very specific a category of people that we're talking about. And that, for me, really does give rise to the fear that we would then be not be able to make a specific determination on that point of them being within the last 12 months of their life. There's the risk either that people actually have many years left to live, and in the case of motor neuron disease, we've seen prognosis is between 2 and 5 years. And so we risk shortening people's lives unduly, but also that people would not want to make that prognosis, and therefore we would potentially, for people who would like to have the right to end their life within the final 12 months because they have a neurodegenerative disorder, they would be denied that right because it is impossible to come to that determination. And the final point I wanted to make about this was that my honourable friend included Parkinson's within the definition of neurodegenerative disorder, and yet we heard from Sir Nicholas Mostyn in his evidence at the oral evidence session that Parkinson's is not a terminal disease. I don't want to litigate that point at length because there is no point if we're not pushing it to a vote, but just to highlight that that's a massive discrepancy in terms of what we're talking about. I expect what my honourable friend means is that if you have a neurodegenerative disorder such as Parkinson's and you're dying from a terminal disease, however, I don't think we should go into that at length because we're not pushing it to a vote. However, I think it's really, really important just to get that point on the record again, that the bill as passed at second reading does not allow for assisted dying in the case of Parkinson's. It does not allow for assisted dying for a diagnosis of greater than 6 months. That is the bill that the House has asked us to consider, and I believe that my honourable friend's amendment would take us outside of that scope. Thank you very much, Chair.
Annie Kruger.
Thank you, Chair. I'll be as quick as I can and recognise the very powerful contributions that have been made in a number of these amendments this afternoon. I just want to start by paying tribute to the Honourable Member for Broxtowe, who I think made a very interesting speech in support of her amendment 1, 2, 3, and I was struck by her point that we should do what we can to reflect the reality of clinical situations in people's lives, and I very much respect the power of the argument she made. My concern, however, is that her amendment, by changing from inevitably to typically, would, although it might reflect reality more closely, would, I'm afraid, in my view, widen the scope of eligibility. So I'm afraid I won't be supporting the Honourable Lady's amendment, but I think she made a very important speech about how things actually work. I want to speak briefly in support of Amendment 282 in the name of the Honourable Member for York Central, and Amendments 48 and 402 in the name of the Member for Bradford West, and I'll just quickly refer at the end to the amendments in the name of the Member for Knaresborough and Harrogate, and my honourable friend, Member for Runnymede and Weybridge. Now, all these amendments to the bill, exception of those last ones, fit the bill to the campaign. So they make the bill more accurately applicable to the people that the campaigners have been campaigning for, who everybody has the most sympathy with. Now, Amendment 282 in the name of the Member for York Central, which would restrict eligibility to people with a 1-month diagnosis only. I want to stress this is a probing amendment. I don't propose to push it on behalf of the member. She tabled it, and I'm speaking to it to make the point that if we're serious about this bill being for people who are dying, and not for people who are not, for people at the very end of their life, as we hear so often, we need to be much stricter about the period of prognosis. And I won't repeat points that have been made by other honourable members. The fact is that 6-month test is literally as good as tossing a coin. It has less than a 50% accuracy. And particularly for advanced cancers, neurological conditions, accuracy is very low. So, happy to give way.
Just very straightforward. Obviously, there has to be some line drawn in the sand. Would the honourable member define what he thinks an adequate timeline would look like to be satisfied?
He invites me to suggest I think it would be possible to draw a safeguard. I don't. I think that 1 month is better than 6 months because with 1 month you can have more accuracy doctors are more genuinely right when they say that somebody is close to death at that point. 6 months is much more inaccurate. 12 months is notoriously inaccurate. But so if we're going to try and restrict the bill using a time limit, the time limit should be as close to death as possible, in my view.
I thank him for giving way, but would he also agree that if we were to reduce this to 1 month, there would be absolutely no way we could have a robust process as set out by the bill? Indeed, I would argue any sort of robust process.
Well, I do accept that, which is why this amendment is probing only. It's trying to demonstrate the point. I mean, I recognise that even with the expedited process, it's likely to take up to a month to get through it. So it would be very difficult. Nevertheless, if our intention is to restrict it to the people who are literally in the last days, which is frequently what we hear about, then I think it would be appropriate to restrict this. So let me, Mr. Chair, move on to the amendments in the name of the Amendment 48 in the name of Member for Bradford West. Happy to give way to that.
Thank the Honourable Member for giving way. I'd wonder if you could comment to the... so when he talks about a probing amendment, the idea of 6 months, do we know whether that was based on research or why we took it as 6 months on its own? I'm not sure if he's aware or whether he can help understand that.
I'm not. I think we've allowed 6 months to creep into sort of common legal parlance because of the Social Security Act of 1992, and we now recognise in law that it's possible to have certain rights and entitlements on the basis of a 6-month prognosis. I presume that's the basis of it. And it does feel like a reasonable period. I do understand the rationale for it, but just given the difficulty of prognosis and the intense seriousness of what we're doing, I think it's inappropriate and dangerous. Now, another way of achieving greater safety, less precise, but I think perhaps more generous to people who want an assisted death, is to tighten the definition of terminal illness to mean those the doctors think it is reasonably certain rather than reasonably expected that they will die within 6 months, which is the amendment moved by the Honourable Lady. The amendment also insists that the condition is terminal with all recommended treatment. So you can't make yourself eligible by refusing treatment. I think that's a very important point the Honourable Lady is trying to insist on in the bill. By the way, it doesn't mean, and I hope people won't conclude that it means that you are required to have every treatment that might be possible, including invasive and unpleasant chemotherapy. The point is that it would have to be recommended treatment by the doctor. So if the doctor recommends it, then it is appropriate. But the doctor would not be recommending, it might be offering, but would not be recommending chemo in all circumstances. And for the avoidance of doubt, important phrase, I think the Honourable Lady's Amendment 402 is very important as well, just in case nutrition is not seen as treatment, which perhaps it's arguable that it might not be. It's very important that we include explicitly that declining food or drink does not qualify you for an assisted death. And quickly to add to the points made by the Honourable Lady, happy to give way to her.
The Honourable Member, would he agree with me? One of the points that's really, really important in this afternoon is that the person has a right to refuse treatment and indeed food and water if they have capacity. If they do, then malnutrition is practically reversible. This argument doctors have made in Oregon around voluntary stopping of eating and drinking. Doctors can't legally force a person with capacity to eat, and if they refuse food, their condition is reversible and terminal. That's the crux of, does he agree with me?
I think the Honourable Lady is absolutely right. There is this difficult loophole that somebody may have capacity, they may be refusing food and drink, and they would therefore be potentially eligible. And in the bill, as it currently stands, we have an expedited process for people who are within 1 month of their prognosis is of only a month. The 14-day waiting period could be reduced to just 48 hours. So if a person stops eating and drinking, their death will almost certainly be likely within a month. So in other words, a person who is not terminally ill could make themselves eligible for an assisted death within 48 hours simply by refusing sustenance. So I think it is very important that we recognise that and explicitly exclude it. And just to refer quickly to other jurisdictions where this specific situation does occur, where voluntary stopping of eating and drinking is used to qualify for legal drugs. A peer-reviewed article in the Journal of American Geriatric Society discusses this case. I think it might be the one referred by the Honourable Lady earlier. the authors noted that if anyone can access VSED, meaning voluntary stopping eating and drinking, then anyone can qualify for medical assistance in dying. In Colorado, 12 people qualified for assisted suicide based on a diagnosis of severe malnutrition. And lastly, the American Clinicians Academy on Medical Aid in Dying, an organisation of doctors who provide assisted suicide. They acknowledge this loophole, and I quote, the guidance states, "There's nothing in the letter of the law to prevent voluntary stopping eating and drinking from being used in this way," and quote, "it essentially eliminates the criteria of terminal illness, because you can always qualify for terminal illness if you stop eating and drinking." That's obviously not what the bill sponsor and drafters wish, and I hope they will consider accepting this amendment to close that loophole. I won't repeat points made very eloquently by my friend for Reigate, but I do echo the point. We need to ensure that the bill is not for conditions which, while they cannot be reversed by treatment, can nevertheless be controlled or substantially slowed. So I'll be supporting the amendments in the name of the member for Northamptonshire South. And lastly, just to the point, the amendment moved by the honourable member for Knaresborough and Harrogate. I mean, I do pay tribute to him and to the people that he speaks for in this amendment. The fact is, I recognise absolutely the MND Society has pointed out the 6-month rule does not work for many, would not work for all MND sufferers. And they successfully persuaded the last government to change the rules on benefits in recognition of this point. And now in their evidence to us, they request clear and workable definition for assisted suicide. They weren't very clear on what that would be, and there are practical problems about extending to 12 months, specifically the one we've got with 6 months. It would be twice as bad, meaning the difficulty of prognosis. I also refer to the evidence from Professor Sleeman, who made the point that a non-neurologist would find it particularly difficult to make an accurate prognosis of a 12-month prognosis for MND. But the main reason to object to the principle of the amendment, which I appreciate he's not moving, but it's an important principle to discuss, the main reason is that it makes no sense at all to have two different qualification periods, two different prognosis periods. And of course we see where it will go. And the fact that the amendment has been tabled and selected, it's in scope, the fact that people will be supporting it, whether in this committee or beyond and outside Parliament, is evidence of where things go. And we saw it very clearly in the evidence we had from witnesses from Australia, who pointed out that there is no logical reason to have two prognoses, one for cancer, one for neurodegenerative disorders. And so what their response is, well, let's make it 12 months for everyone. And of course that is the way things would go. And I'll finish there, Mr. Chairman, just with one particular tribute to the great quixotic effort of my honourable friend who's not on the committee, the member for Runnymede and Weybridge. Runnymede, home of Magna Carta, the spirit of liberalism, lives on in my honourable friend, a genuine liberal, who wants to just scrap the period of prognosis altogether, because he genuinely believes in absolute autonomy. I've been trying to make this bill live up to its claim to be a bill for safeguarding. He wants it to live up to its claim to be a bill for autonomy. And of course, in principle, in logic, he's absolutely right. If we think that some people should have access to suicide assisted by the state, then why should person A get it and not person B? Needless to say, I disagree with him. Thank you.
Lewis Atkinson.
Thank you, Mr. Chair. I stand to speak in favour of the current tightly drawn eligibility criteria of 6 months terminal diagnosis. I agree with my honourable friend from Bradford West. This was a central plank of the bill as introduced and as debated across the House at second reading, and therefore I rise to speak against all of the amendments moved in this clause. Dying people want to put their affairs in order, and that includes thinking about the death that they want and how they want to spend their time with their families. Dying people don't want to die, but they haven't got an option to live, and I feel like the way we talk about death hasn't perhaps been fully reflected in the debate we've had on these sets of amendments. The evidence from elsewhere that is very clear in my mind, that those who seek assisted dying seek the approval, going through the safeguards that are significant as set out in this bill, so they can spend the remaining time with their families with enhanced feelings of control and autonomy, removing some of the fear of what if I will have no way out of inevitable pain. That does not mean, of course, that people wish to die more quickly. It does not mean the fact that there is a 6 months eligibility criteria as set out in the bill, that people will be rushing to end their own lives as soon as they are possible to do so. It means that 6 months is the threshold to which they can start potentially exploring the options, getting the onerous, rightly onerous, as set out in this bill, through 8 different stages of capacity checks, 3 different stages of approval, multiple doctors, etc. So they have the option. And indeed, where we know that elsewhere, as my honourable friend from Spen Valley has set out earlier, there is a significant proportion of people elsewhere who, having been approved for assisted dying, do not take up that option. Because their death, because their end of life is not painful, and that's fantastic, or it can be managed through palliative care, and that's something that we would all want. But knowing that they have the option significantly increases the quality of their life and their ability to relax with their families and to spend time with their loved ones. So, where there are cases where the progression of terminal illness progresses more slowly than maybe otherwise be the case, and clearly I accept that as evidence we've heard, prognosis is not an exact thing. If and when people's terminal illness progresses more slowly than might be expected, dying people are delighted. They don't think, oh, well, okay, well, I've got this approval, I'm going to access assisted dying anyway. So I feel like some of the debate we've had misses the essential human nature of the humanity of people at the end of their lives. And that just because people are able to do something means that they will. And actually, that is as much about the autonomy that we're talking about and the dignity and the respect in this debate that I have. Yes, I will.
I thank the Honourable Member. He's making a very powerful speech, and I agree with what he's saying in terms of autonomy. If it is just about autonomy, then autonomy, as I've said earlier, doesn't necessarily have to lead to pain. It could be that I don't want to get to that stage. They'll never know whether they could have lived longer. Does he not agree?
I think
elsewhere, I mean, not essential in the clauses that we're talking about, Chair, but elsewhere, you know, there are sensible amendments strengthening the initial conversation, making sure that people have an informed decision and got access and conversations about all of the forms of support, psychological or otherwise, which I think will address the Honourable Lady's point. But in terms of the eligibility criteria, the matter for this discussion, that diagnostic uncertainty, as Chris Whitty was clear, there is uncertainty in both directions. So, meaning, and I quote, a significant minority of people die before they get to the 6 months of the prognosis. So, because of that uncertainty, but if we attempted to tie the eligibility criteria much shorter than 6 months, we would end up excluding people. And because people, once they have a terminal diagnosis, want to put their affairs in order, from all of the conversations that I've had, doing so means that they can do that and enjoy their final months with their families, and that we do not reduce eligibility to limit access to those who, unfortunately, whose disease progresses faster than they would like, and that the prognosis is the case. So therefore, of course, I oppose Amendment 48 in the name of my honourable friend from Bradford West. Also, you know, that amendment talks about recommended treatment. You know, in all my years in the NHS, a key principle is around shared decision making. And no one else other than I, or the person in question, can make a decision about what is the trade-off I'm willing to accept between invasive chemotherapy that may have a 20% chance of elongating my life. Am I willing to accept a 20% chance? Am I willing to accept a 30% chance? What I decide is right for me is maybe different to what other individuals decide. So the idea that a doctor is in a position to recommend, to say, oh, well, you should accept this because it will give you a 10% chance, or it will give you a certain level of pain that I'm willing to accept, but you're not willing to accept. We each have to make decisions on that ourselves. No, I'm going to make some progress, thank you. I do feel like that amendment risks pressuring people to accept courses of intervention against their will. And I don't think that's consistent with the principles of autonomy and consent that are important. Now, because of the safeguards and the approvals and the reflection periods that are built into the bill, going through the process of approval for someone will take clearly in excess of a month. So that is why the amendment of 282, has always been mentioned, I think it's not going to be moved, from the member for York Central, limiting eligible to 1 month, is fundamentally not compatible with the safeguards in the bill, as my honourable friend from Spen Valley has made clear. So 6 months to me is absolutely the right balance, reflecting the need for people, the wish for people to put their own affairs in order, to get to a point, to allow for prognostic uncertainty on the downside, that someone given 6 months may actually only have 2 months or 3 months to live. But still to allow the operation of robust safeguards and reflection periods. I turn briefly to other amendments, if I may. I commend my honourable friend from Broxtowe, again, for the points that she made. I also, though, share concerns that replacing inevitably with typically would risk weakening the definition of terminal illness, expanding access to conditions which may, at the moment, are inevitably progressive. I fear that the typically progressive is a weaker interpretation of that, and I therefore cannot support that, because I support a tightly drawn bill with tightly drawn eligibility criteria. For the same reason, while I have sympathy with the member for Harrogate and Knaresborough's amendment, I do think it goes beyond the scope of what the House discussed in November and the contours of the current debate. I turn now to amendments 9 and 10, which refer to disease being controlled or substantially slowed. These are not recognised medico-legal terms. So what's the definition of substantially slowed? Who would define that? Is that, it takes 20% longer, 50% longer, 100% longer? We talk about the risks of inserting undefined terms and risking court interpretation of this. By introducing an amendment like that, I fear we are permanently doing that. The people who are best placed to make decisions about whether treatment will suitably slow the progression of disease are dying people themselves. They're the only people, and they, of course, should do so fully informed by their medical and clinical teams, etc. But each of us, when the end is nigh, as it will come to me as us all, have to make that decision ourselves, not on the basis of a recommendation mandated in law or some definition of controlled or substantially slowed, where the legislature is putting in primary legislation what the decisions it feels that I should make about treatment I should accept. So I'm not in favour of those amendments. I finish, I think, with reference to Amendment 402, and just to be clear, I wanted to make some progress before, but I don't want to rule out any further interventions if our honourable friend or others would like to come back in. I recognise the concern, and I think we need to talk about the issue and the concerns around people with anorexia with the respect and dignity and seriousness that deserves. I've heard it said, I think the Honourable Member for Bradford West said that there is nothing in the current bill to stop that being the case, and I fundamentally disagree. I fundamentally disagree for many, many reasons. First of all, that as set out in this bill, capacity is checked 8 times. The Court of Protection has repeatedly found that people with anorexia do not have the capacity to make decisions around stopping eating. And while a best interest test may have been made, a best interest test is not relevant as set out in this bill. Yeah. People have to have the capacity to to request an assisted death. Checked 8 times. My honourable friend from Spen Valley has already set out that she is minded or will accept the amendment to Clause 9, subsection 3b, talking about if there is any doubt to capacity, a psychiatric opinion must be sought. So I too, like my honourable friend from Bradford West, considered the written evidence saying that in those instances of a patient with anorexia, psychiatric input is absolutely necessary. Absolutely. In every case where someone has anorexia, with an amended Clause 9, a psychiatric opinion must be sought as to capacity. And that's before we get to the further set of amendments around Clause 12, of course. Yes, of course I will.
I thank the Honourable Member for giving way. Perhaps I could just clarify. When we're talking about capacity, and in the cases that went before the court, the judges in 9 or 10 cases found that all those young ladies did indeed have capacity to refuse their food. And it was as a result of that that their death became inevitable. So would he, how would he comment to that?
Chair, that's not my understanding, and I've sought some clarification, including from Professor Hoyano, who gave evidence to us in oral stage, and that's not her. I believe that's not her understanding either. But very clearly, you know, with the must involved in Clause 9 to psychiatric referral, to a third-tier panel, which, again, let's remind ourselves, is not in place in any of these jurisdictions in which the figures are quoted around potential deaths of people with anorexia. I feel there is significant safeguards. And furthermore, we've just agreed to the Honourable Member for East Wiltshire's Amendment 399, I think, clarifying the medical conditions piece, which I think provides a further safeguard on that. So I absolutely respect that we need to be considering these matters carefully, but I would just urge a level of holistic thinking while we talk about individual clauses. Some of the statements being made that there are no protections in place for this just does not, to me, fly at the face of the bill as a whole. So I think that I'll wrap up there, Chair. I think Clause 2 does a difficult job as is currently drafted very well.
Give way.
Of course I will, yes.
Would he agree with me, and he is correct in his interpretation of the judgments in those cases, but would he agree with me that it is also helpful, in fact, the evidence that was given by Chris Whitty to clarify his statement, that was indeed helpful in clarifying the fact that the application of the test for capacity is heavily orientated towards the gravity and complexity of the decisions to be made, and that is also underpinned, as my honourable friend underlines, with the amendment put forward by the member for Spen Valley.
I do, and I thank her for bringing my attention to that. I was struggling to put my hands on it. So, Chair, the Clause 2 does a difficult job very well, in my view, on tightly drawing eligibility criteria. So the bill does what it says on the face of it, that it allows access for terminally ill adults at the end of their life. By having a 6-month prognosis rather than anything else, it allows individuals to put their lives in order and to have the best last months of their lives possible, and therefore I speak against the amendments and in favour of the clauses as currently drafted.
Thank you. Minister.
Thank you very much, Chair. As usual, I'll make brief remarks on the legal and practical impact of amendments, whilst emphasising that the Government continues to remain neutral on this bill and on assisted dying more broadly. This series of amendments seeks to change the definition of terminally ill, either widening or narrowing the cohort of people able to access assisted dying services. I will take the amendments in turn. 123 changes what is to be terminally ill for the purposes of the bill from having an inevitably to a typically progressive illness, disease or medical condition that cannot be reversed by treatment. This would widen the pool of those able to access assisted dying services by reducing the level of certainty which a doctor must have that the illness, disease or medical condition in question is progressive, from one which is inevitably progressive to one which is typically progressive. Amendment 9 seeks to amend the definition of terminally ill such that a person who has an inevitably progressive illness, disease or medical condition which can be reversed, controlled or substantially slowed by treatment would not meet the definition of terminally ill. The effect of the amendment is that such a person would not be eligible to be provided with lawful assistance to voluntarily end their own life. Should this amendment be accepted, the effect would be to restrict eligibility for assisted dying services to a narrower category of patients than is currently set out in the bill. The amendment may make assessments of a person's prognosis and eligibility under the bill more extensive, as it would be likely to require an assessment of a broader range of treatment options. Amendment 48 would require the coordinating doctor and independent doctor to have reasonable certainty that a person can be expected to die in consequence of their inevitably progressive illness, disease or medical condition within 6 months, even if that person were to undergo all recommended treatment, thereby narrowing the scope of those caught by the definition of terminally ill. The amendment could have the effect of making the assessment of a person's prognosis more complicated from the point of view of the assessing doctors. It is an established and important principle that a patient with capacity should always retain the right to refuse treatment if that is their wish. 282 is similar to Amendment 48, but it would require the coordinating doctor and independent doctor to have reasonable certainty that a person can be expected to die in consequence of their inevitably progressive illness or disease within 1 month instead of 6 months, even if that person were to undergo all recommended treatment. As with Amendment 48, this carries risks of making the assessment of a person's prognosis more complicated from the point of view of the assessing doctors. I've already set out why that can be challenging. It is an established principle that a patient with capacity must always retain the right to refuse treatment if that is their wish.
Sorry,
as this amendment...
I thank the Minister for giving way, and I apologise to the member of the Sunderland Central. I was actually incorrect. It was they didn't have capacity. He was actually correct. But in the cases that went before the court, those 9 girls didn't have the capacity, but yet the judge made a decision that they should not be force-fed to keep them alive and to allow them to die. So perhaps you could comment on how this amendment wouldn't meet that criteria. Wouldn't fix that loophole.
I thank her for that intervention. I'm just talking at the moment about the amendment to reduce the time from 6 months to 1 month. I will come on to the issue about eating and drinking in my comments in a second. As this amendment reduces the time within which the person is expected to die from 6 months to 1 month, this amendment would also limit the number of people with a terminal illness who would be eligible to access assisted dying under this legislation. Furthermore, there may be very challenging workability issues in respect of delivering a service within 1 month, given the other time-dependent safeguards elsewhere in the bill. Turning to Amendment 51, the purpose of this is to remove the requirement for the patient to have a 6-month prognosis to be defined as terminally ill. This, if agreed to, would expand the pool of people eligible to be provided with lawful assistance to voluntarily end their own life beyond those with a 6-month or less life expectancy. In other words, it would remove the time frame requirement of when death can be reasonably expected. Amendment 234 seeks to widen eligibility to include cases of neurodegenerative diseases, illness, disease or medical conditions has gone now, hasn't it? So, where a person is reasonably expected to die within 12 months. Matters such as this are for the committee and ultimately for Parliament to decide. But it is clear that the effect of this would be to broaden the number of people eligible to be provided with lawful assistance to voluntarily end their own life under this legislation. Amendment 10 provides that if treatment exists for a person's progressive illness, disease or medical condition which alters the overall prognosis of that person's condition, then they are not terminally ill and would not be eligible to access assisted dying services. Amendment 402 seeks to exclude a person who would not otherwise meet the definition of terminally ill, namely being diagnosed with an inevitably progressive illness within 6 months or less to live, if the person meets that definition as a result of stopping eating or drinking. The effect of the amendment would be to prevent a person from being defined as terminally ill as a result of their own actions from stopping eating or drinking or both. The government's analysis suggests that this may also exclude people who are terminally ill under the definitions of the bill and who are for various reasons unwilling or unable to eat or drink. This may, for example, include those with conditions such as esophageal cancers, which could result in them being unable to eat or drink. Furthermore, it is unclear whether someone who is on intravenous fluids or being fed through a feeding tube would be considered to have stopped eating or drinking under this amendment. So I think that responds to the concern from my honourable member for Bradford West, which she's very welcome to intervene again if she'd like to. This amendment may therefore lead to uncertainty as to the person's eligibility for assistance under the bill. The government has taken a neutral position on the substantive policy questions relevant to how the law in this area could be changed. Questions around the definition of terminal illness and who should be eligible to access voluntary assisted dying under this legislation are matters for this committee and for Parliament as a whole. However, I hope these observations are helpful to members of the committee in considering the bill and the amendments put forward by various members. Thank you, Chair.
Thank you. Kim Leadbeater.
Thank you, Chair. Colleagues will be pleased to know that despite my copious amounts of notes, I don't intend to speak for very long because I believe we've had a very thorough and robust debate today on these issues. Other than to say, in response to the Minister's comments today, he makes a very valuable point, actually, which I don't think anyone raised around that Amendment 402. And coincidentally, it relates to the person we had with us in the audience in the gallery this morning, whose mum had a very horrible form of cancer where she had her tongue removed, and actually she would have stopped eating and drinking, but it wasn't a choice. It was an inevitable result of her condition, and therefore she would have been excluded from having assisted death, which I'm sure isn't the intention of the honourable member. So I think we've had an excellent debate. We've covered a lot of ground. I don't intend to add anything more to this selection of amendments, other than to say if we get a move on, we might be able to get through our second clause before we close at 5 o'clock. Thank you, Chair.
Thank you. Juliet Campbell. I will not be moving the decision.
Thank you. In that case, is everyone content? Are we withdrawing the amendment? Or yes, okay. So is everyone content for the amendment to be withdrawn? Agreed. Agreed. Amendment withdrawn by me. We now move on to Amendment 9. I don't know whether the member for Reigate wishes to move this.
I would like to move this.
Okay. In that case, Amendment 9 to Clause 2 was debated with Amendment 1, 2, 3 to Clause 2, and I call Rebecca Paul to move the amendment formally.
Thank you, Chair. I formally move.
Okay. Amendment 9 to Clause 2, as on the amendment paper, the question is that the amendment to be made, as many as of that opinion say aye. Aye. On the contrary, no.
No.
Division, I think, a division. Okay, we ready? Yeah, we okay? Everyone's here? Yes. Lock the doors.
Jack Abbott. No. Lewis Atkinson.
No.
Juliet Campbell.
Aye.
Bambos Sherwood-Lambos.
No.
Daniel Francis.
Aye.
Tom Gordon.
No.
Sarah Green. No. Rachel Hopkins. No.
No.
Thank you. Sojourn Joseph.
Aye.
Stephen Kinnock.
No.
Danny Kruger.
Aye.
Kim Leadbeater.
No.
Kit Malthouse.
No.
Sarah Olney. Dr. Simon Oper.
No.
Rebecca Paul. Aye. Jake Richards.
No.
Sarah Sackman.
No.
Liz Saville-Roberts.
No.
Naz Shah.
Aye.
Dr. Neil Shastri-Hurst.
No.
Dr. Mary Tidball.
No.
Sean Woodcock.
Aye.
The ayes were 8, the noes were 15, so the noes have it, the noes have it. Unlock, yes. We now on to Amendment 400 to Clause 2 was debated with Amendment 399 to Clause 2. I call Danny Kruger to move the amendment formally.
Formally.
Okay. Amendment 400 to Clause 2, as on the amendment paper. The question is that the amendment be made. As many as of that opinion say aye.
Aye.
On the contrary, no. I think the ayes have it. The ayes have it. Amendment 48 to Clause 2 was debated with Amendment 123 to Clause 2. I call Naz Shah to move the amendment formally. Okay. Amendment 48 to Clause 2, as on the amendment paper. The question is that the amendment be made. As many as of that opinion say aye.
Aye.
On the contrary, no.
No.
I think we'll go for a division again on that to be certain. Division. Everyone's in the room. Lock the doors.
Jack Abbott. No. Lewis Atkinson.
No.
Juliet Campbell.
Aye.
Bambos Charalambos.
No.
Daniel Francis.
Aye.
Tom Gordon.
No.
Sarah Green. No. Rachel Hopkins.
No.
Sojourn Joseph.
Aye.
Stephen Kinnock.
No.
Danny Kruger.
Aye.
Kim Leadbeater.
No.
Kit Malthouse.
No.
Sarah Olney.
Aye.
Dr. Simon Oper.
No.
Rebecca Paul.
Aye.
Jake Richards.
No.
Sarah Sackman.
No.
Liz Saville-Roberts.
No.
Naz Shah.
Aye.
Dr. Neil Shastri-Hurst.
No.
Dr. Mary Tidball.
No.
Sean Woodcock.
Aye.
The ayes were 8, the noes were 15, so the noes have it, the noes have it. Unlock. Amendment 282 to Clause 2 was debated with Amendment 123 to Clause 2. I call Rebecca Paul to move the amendment formally. This is Amendment 282 to Clause 2. Do you wish to push it to a vote?
I thought you weren't here, guys.
Do you wish to put it to a vote? No.
That's the month.
No.
No, we're not.
Yes. Sorry. Does anybody? Sorry. Yes. Does anybody actually want to move it? Do you want to move 282 to Clause 2? No, we're not on that one.
No.
Just bear with me. We're not on that. Just order. We're dealing with Amendment 282 to Clause 2. It was debated with Amendment 123 to Clause 2. Rebecca Paul didn't want to move it. I'm giving you the opportunity to move it now. The amendment, therefore, is not moved. Amendment 51 in the name of Dr. Ben Spencer to Clause 2 was debated with Amendment 123 to Clause 2. The member isn't here. Would anybody wish to move it? No? Okay, so the amendment's not moved. Amendment 234 to Clause 2 was debated with Amendment 123 to Clause 2. You indicated you didn't wish to move the amendment. Is that correct? Yes, okay. Amendment not moved. We now come to Amendment 112 to Clause 2 in the name of Sarah Brule, which was signed by Danny Kruger, with which it will be convenient to consider Amendment 30. I call Daniel Kruger to move Amendment 13. 12, beg your pardon. If you wish to.
Yes, I beg to move.
Okay. Speak to this, yes.
Yes, thank you. Thank you, Mr. Chairman. Right. So I'll be fairly quick on this one, but these amendments do go to the heart of things, because we've tried to tighten the bill by defining terminal illness itself, excluding from the definition of medical conditions, and I'm very pleased that the committee has accepted that tightening. We've also sought to exclude illnesses that are consequent on mental disorders and disabilities. We've not succeeded with those tightening. And we've also tried to tighten it by circumscribing the prognosis period more precisely. These amendments try to tighten the bill further by explicitly listing the illnesses that qualify, and it's quite a straightforward argument. The problem we're trying to address here is that currently under the bill it is up to doctors and potentially the court or a panel, if that's where we go to decide whether a particular condition is terminal or not. As it were, it would be set by case law and by medical doctors deciding what conditions qualify. And we know from Oregon and other places that doctors have classified as terminal illnesses many of the conditions, the diseases and illnesses that we've been describing, including anorexia, including arthritis and others. And we know from case law here in the UK that the Court of Protection has accepted these descriptions of illnesses as terminal. So there is a real risk of a slippery slope. And I fully recognise arguments made by honourable members that this is a small minority. This is not who the bill is intended for. But I do want to emphasise we need to make the case that even where the overwhelming majority of cases that we expect to come forward would be those that would be understandable in the terms set by the sponsor and the advocates, nevertheless the bill retains these loopholes which need to be closed. And my suggestion is that if these amendments are not accepted, there is no way of protecting against this unintended expansion. These amendments ensure that only Parliament can approve of the expansions, which no doubt would arise as medical science develops, or as society changes. It might well be that the list of conditions specified would adapt. That would be a job for ministers and for Parliament to determine whether expansions should be accepted, rather than just simply allowing doctors and the assisted dying panel and the Commission to set the rules. Without it, there's no expansion against the slippery slope. And just to make a point about the legal interpretation of the law, Mr. Chairman, when something is not on the face of the bill, it is an invitation to lawyers and to courts to interpret the legislation permissively, for courts and cases to test the boundaries of the law and to expand the law progressively in accordance with the evolution of case law. And if we're content with that, let's say so. But I don't think we are. I think the expectation set by Parliament and by the public is that this will be a tightly circumscribed bill, allowing assisted dying only for those cases where we all understand it might be appropriate. And now my concern, just to finish, is that we are at risk throughout this debate of a skeleton bill. It's long because it's complicated, but actually so many of the key considerations, the key questions about how the bill will operate in practice, what conditions would be eligible, what drugs would be used, will be determined not by Parliament, often by ministers using the negative procedure, or in fact in this case simply by the panel and by doctors themselves. So I really do suggest that if we're serious about safeguards, about preventing the slippery slope, let's insist that this bill's any further expansion or evolution is determined not out there, but in here. Let Parliament be the sovereign power that determines what is eligible and what isn't. Thank you.
Lewis Atkinson.
Thank you, Chair. I'll be very brief, speaking in opposition to these amendments. I think it was the Honourable Member for Richmond Park who, in oral evidence sessions, asked the Chief Medical Officer if some people, is it possible to come up with a list of illnesses that are terminal that would qualify under the legislation? And the response was very clear. If I'm honest, I think that would be very difficult, because it's difficult in both directions, because actually some illnesses or diseases can be terminal, but absolutely are not necessarily terminal. People can live with prostate cancer for many years. So actually, far from, I think, the intention of this amendment, setting out a list of specific diseases or illnesses that would be eligible under this Act, risks doing exactly the opposite and on that. But equally, on the other side, there are people who may not have a single disease, and this is quoting from Professor Whitty, that is going to lead the path to death, but have multiple diseases interacting. So I think it's quite difficult to specify that certain diseases are going to cause death and others are not, because in both directions that could be misleading. And further, the Honourable Member from East Wiltshire's point in terms of judicial oversight, I have to say, from my understanding, giving power to the Secretary of State to make a list where some diseases are on and some are not is absolutely inviting judicial action through the courts in terms of the reasonableness of why one disease is on the list and others are not. And I think we would end up in a much more of a legal quagmire than we would otherwise do. The safeguards that we've talked about are in the bill as it stands in terms of the eligibility criteria, the terminality, the capacity, etc. They are the safeguards that we need, and a list would further muddy the water and create confusion. Thank you, Chair.
Thank you. Minister.
Yes, thank you, Chair. Very brief comments. These amendments seek to further define a terminal illness for the purpose of the bill, and I will set out some details about their effect. Amendments 12 and 13 seek to add a requirement that a list of the terminal illnesses for which people are eligible to seek assistance under this bill are specified in regulations made by the Secretary of State. The effect of the amendment would be that only a person who has an illness, disease or medical condition listed in regulations and who meet the other eligibility criteria would be eligible to be provided with lawful assistance to voluntarily end their own life. In considering this amendment, I would draw the attention of the committee to the Chief Medical Officer's oral evidence given on the 28th of January, which was just very well articulated by my honourable friend, the member for Sunderland Central. He said, the CMO said, that multiple diseases may interact, making it quite difficult to specify that certain diseases are going to cause death and others are not. It is also the case that many illnesses, diseases or conditions that may be terminal in one case may not be so in another. Committee members may therefore wish to consider where a focus on specific illnesses or diseases rather than on the facts of an individual case could aid clinicians in their decision making. The amendment also includes a discretionary power for the Secretary of State to make regulations which expire after 12 months in order to list temporary additions to the list of illnesses which meet the definition of terminally ill. It is not clear what types of illnesses, diseases or medical conditions are intended to be captured in such regulations. As I said earlier, I do hope that these observations on the purpose and effect of Amendments 12 and 13 are helpful to members of the committee in their consideration. Thank you, Chair.
Thank you. Kim Lead, Peter.
I have nothing to add, Chair.
Okay, thank you. Danny Kruger.
Well, very quickly, I sense the wish of the committee is to proceed and probably not to accept this amendment, so I don't propose to push it. But we've just heard quite clearly in response to this amendment that this bill is essentially permissive. Once again, we have declined to put clear parameters around the eligibility for this new law. And so many times we've heard specific conditions mentioned in the course of the debates over preceding months. And it's a shame we're not prepared to state those conditions clearly on the face of the bill, with the opportunity for Parliament to amend it over time. I would just end with echoing a point made by the Honourable Lady for Spen Valley when she stresses the importance of data, good data. I hope if this bill passes into law, we will have the best data collection in the world, because I'm afraid to say data collection is not good in other jurisdictions. Nevertheless, it is possible to see in Oregon, in Australia, in Canada, in Europe, how often it is the case, only in a minority of cases, nevertheless, conditions that most people would not recognise as deserving of assisted dying, including anorexia, but also including arthritis, including hernias, including diabetes, are listed as causes of death, and indeed frailty as well, as I discussed earlier today. So my fear is that if we pass this bill, we too, if we do data collection properly, will have this shameful appendix to the annual report showing that people have had an assisted death for reasons that I think most people would regard as inappropriate. But with that, I'll leave it, Mr. Chairman. I don't propose to push these amendments to a vote.
Given that the honourable member has not decided to push it to vote, is everyone content for the amendment to be withdrawn? Aye. All those in favour say aye. Amendment by leave withdrawn. We now come to Amendment 401 to Clause 2, which was debated with Amendment 399 to Clause 2. I call Danny Kruger to move the amendment formally.
Move formally.
Amendment 401 to Clause 2 as on the amendment paper. The question is that the amendment be made. As many as of that opinion say aye. Aye. On the contrary, no. I think the ayes have it. The ayes have it. Amendment 10, in the name of Sarah Poole, to Clause 2 was debated with Amendment 123 to Clause 2. I call Rebecca Ball to move the amendment formally if you so wish to do. Okay, so you're not moving the amendment. Agreed. Amendment 402 is in the name of Naz Shah to Clause 2, which was debated with Amendment 123 to Clause 2. I call Naz Shah to move the amendment formally. Amendment 402 to Clause 2 on the amendment paper. The question is that the amendment be made. As many as of that opinion say aye. Aye. On the contrary, no. No. In that case, I think the noes have it, but I'm happy if people wish to take the division. You wish to take the division. In that case, division. Lock the door. Lock the doors. Thank you.
Jack Abbott. No. Lewis Atkinson.
No.
Juliet Campbell.
Aye.
Lambos Lambos.
No.
Daniel Francis.
Aye.
Tom Gordon.
No.
Sarah Green.
No.
Rachel Hopkins.
No.
Sojourn Joseph.
Aye.
Stephen Kinnock.
No.
Danny Kruger.
Aye.
Kim Leadbeater.
No.
Kit Malthouse.
No.
Sarah Olney.
Aye.
Dr. Simon Ofer.
No.
Rebecca Paul.
Aye.
Jake Richards.
No.
Sarah Sackman.
No.
Liz Seville-Roberts.
No.
Naz Shah.
Aye.
Dr. Neil Shastri-Hurst.
No.
Dr. Mary Tidball.
No.
Sean Woodcock.
Aye.
The ayes were 8, the noes were 15, so the noes have it. The noes have it. Unlock. Amendment 11. Amendment 11 is in the name of Sarah Poole to Clause 2 and was debated with Amendment 399 to Clause 2. I call Rebecca Ball to move the amendment formally if she so wishes. Okay. Amendment 11 to Clause 2 as on the amendment paper. The question is that the amendment be made. As many of that opinion say aye. Aye. On the contrary, no. No. I think the ayes have it, but I will be consistent and go for a division. Division. Lock the doors. Okay.
Jack Abbott. No. Lewis Atkinson.
No.
Juliet Campbell.
Aye.
Lambos Lambos.
No.
Daniel Francis.
Aye.
Tom Gordon.
No.
Sarah Green.
No.
Rachel Hopkins.
No.
Sojourn Joseph.
Aye.
Stephen Kinnock.
No.
Danny Kruger.
Aye.
Kim Leadbeater.
No.
Kit Malthouse.
No.
Sarah Olney.
Aye.
Dr. Simon Ofer.
No.
Rebecca Paul.
Aye.
Jake Richards. Sarah Sackman.
No.
Liz Saville Roberts.
No.
Naz Shah.
Aye.
Dr. Neil Shastrihurst.
No.
Dr. Mary Tidball.
No.
Sean Woodcock.
Aye.
Thank you. The ayes were 8, the noes were 15, so the noes have it. The noes have it. Unlock. Amendment 181 to Clause 2 in the name of Kim Leadbeater was debated with Amendment 399 to Clause 2. I call Kim Leadbeater to move the amendment formally.
Move formally, Chair.
Amendment 181 to Clause 2 as on the amendment paper. The question is that the amendment be made. As many as of that opinion say aye. Aye. On the contrary, no. I think the ayes have it. The ayes have it. We now move to Amendment 283 to Clause 2 in the name of Rachel Maskell, and which was debated with Amendment 399 to Clause 2. Is there any member who wishes to move that amendment? Okay, Rebecca Paul to move it formally. Amendment 283 to Clause 2 as on the amendment paper. The question is that the amendment be made. As many as of that opinion say aye.
Aye.
And on the contrary, no.
No.
I think the ayes have it. The noes have it, but I think the noes have it, but I will go for a division. Lock the doors. Thank you.
Jack Abbott. No. Lewis Atkinson.
No.
Juliet Campbell.
Aye.
Bambos Charalambos.
No.
Daniel Francis.
Aye.
Tom Gordon.
No.
Sarah Green.
No.
Rachel Hopkins.
No.
Sojourn Joseph.
Aye.
Stephen Kinnock.
No.
Danny Kruger.
Aye.
Kim Leadbeater.
No.
Kit Malthouse.
No.
Sarah Olney.
Aye.
Dr. Simon Ofer. Rebecca Paul.
Aye.
Jake Richards. Sarah Sackman.
No.
Liz Saville Roberts.
No.
Naz Shah. Dr. Neil Shastrihurst.
No.
Dr. Mary Tidball.
No.
Sean Woodcock.
Aye.
The ayes were 8, the noes were 15, so the noes have it. The noes have it. Unlock. 13, Amendment 13 to Clause 2 in the name of Sarah Bull was debated with Amendment 12 to Clause 2. I call Danny Kruger to move the amendment formally. Agreed that it's withdrawn. We now come to the question that Clause 2 as amended stand part. The question is that Clause 2 stand part of the bill. As many as of that opinion say aye. Aye. Of the contrary, no. I think the ayes have it. The ayes have it.
I beg to move that further consideration of the bill be now adjourned.
The question is that further consideration of the bill be now adjourned. As many of that opinion say aye. Aye. Of the contrary, no. I think the ayes have it. The ayes have it. Good evening. Thank you very much.